Morning to everyone. Morning. Firstly, a big thank you to Architectural, all the members of Tort who have taken the time and effort on this Saturday morning to come here to hear a little bit of what we have to share. I really appreciate the fact that you're making time. And I hope that based on what we have, or what I have gone through the course, have something to share with you all that will be of benefit to all of you all in the days and years to come. Alright? So without much ado, architects help to navigate legal challenges in contract law. Before I begin, as professionals, whether we are architects, whether we are engineers, whether we are lawyers, whether we are doctors, one of the biggest worries, concerns that we have, and I believe you'll agree with me, are claims made under the law, negligence claims, of course, and again, contractual claims in which we are involved. How do we deal with these challenges? What do we do? How do we go about it? So today's talk is going to cover three key areas. We'll begin by going through challenges in tort, negligence claims. What are the principles of law applicable there? Number two, we go into contractual claims. What are the type of contractual claims? What are elements of contract that would be useful, I believe, to all of you all? And thirdly, how do you resolve those disputes? What are the dispute resolution mechanisms? And we talk about dispute resolution mechanisms, of course, there are issues of negligence, which go to the courts. If there are claims regarding contract, they're going to focus the pen to some of the contract, form and conditions of contract. Now, to make things a little more interesting, as I say, I would appreciate if you have questions, ask immediately. We don't need to wait at the end of the session to ask questions. As I said, I am here just as much as to learn just as you all are, but we have valuable experiences on the field. So let make it a two-way kind of thing. If you have questions to ask, anything you're not too sure about, please be glad to stop and just answer those questions. So don't feel hesitant to ask questions. Alright. And again, thank you so much for having us here. Let's make this session a useful and valuable session. Since we all live a Saturday morning to productivity. Alright. Now, as I said, today's talk is going to cover three key areas. Number one, navigating legal challenges in tort negligence claims, navigating legal challenges in contract, and thirdly, of course, dispute resolution methods. How we go about solving these problems, especially under the ban conditions in form of contract. Now, when we talk about navigating legal challenges in tort, what we'll be covering today are general principles of now we'll cover general principles of negligence claims against negligence. Recent amendments to the law of limitation. Recent amendments to the law of limitation and potential defenses for engineers. So when you talk about the law of limitation, you all are aware there has been a recent change as to the law when it comes to limitation. Previously, you always look at limitation for the Limitation Act of 6 years. I'm sure you all are aware of this. But there has been a change, especially when it involves latent defects that are not visible to the human eye, at least not on first glance. And lastly, of course, we will talk about what are the potential defenses for engineers. That's the most important thing here now, isn't it? We want to know how we protect ourselves, how we make sure that we don't get. We are all here to do our job. We want to be across the court the whole day, or arbitration, adjudication, or whatever you call it. All right. Now, when we talk about negligence claims generally, the first element for any negligence claim is to establish a cause of action. For any case that comes to court, we get a client that comes to court as lawyers and solicitors. The first thing that we need to identify is the principles in legal use to put. You need to identify a cause of action. In simple words, on what basis are you suing somebody? Is it on contract? Is it based on tort? And so on and so forth. So number one, you need to have a person who gets sued. This is important. Number two, another person who can be sued. I'll explain why this is important. And when all the facts that have happened are material to entitle the plaintiff to succeed. In other words, the person who can sue is the first issue here. We have scenarios in which the person who is suing doesn't have the locus standi to sue. This would be the first line of attack if you are the opposing lawyer. Number two, who are you suing? Do you have the right to sue the person? And thirdly, what are the material facts that enable you to succeed? In the following slides, as we discuss issues of negligence, we understand why this is important or crucial. Now, basic elements of tort, I'm quite sure you all are aware of that. In order to identify whether or not we have a case on tort, we need to identify that we have a duty of care. All of us here. All of us here, as professionals, we have a duty of care to our clients. Correct? Number two, is there a breach of the duty of care? Now, this is the second issue. The party that asserts that there is a breach of duty of care needs to come to court and show, or arbitrator, or whatever it is, when we face it, the court, to show indicate that there is a breach of the duty of care. Thirdly, that because of that breach of the duty of care, there are resulting damages. And lastly, of course, the damages must be foreseeable and not remote. In other words, what you did must be the direct cause, or there must be a causal link between what you did or did not do with what actually happened. All these are basic elements of the law. I'm quite sure you're aware of this. Now, but this is crucial. Now, the first test when it comes to duty of care is what we call the Boland test. The ordinary skill of an ordinary competent man exercising that particular art. Why is this important? Now, as professionals, I'm quite sure that we all agree that we have to stay abreast of the latest developments in our profession, the latest changes in technology, especially so in a field that is moving so fast like architecture, engineering, and so on and so forth. So, what is the duty of care here as professionals? Meaning, what happens if, for example, you are unaware of some latest changes in certain technologies related to soil testing, for example, and due to that, the absence of doing that, something happens on site, there's an accident on site. What happens then? This has actually, or this issue has actually been covered in one of the cases that we're going to cover later, in which that if you're not aware of the latest changes in your industry that you want to be aware of, due to that, something happens, you have effectively breached your duty of care. So, duty of care is why continuous professional development, according to the today, is absolutely essential. It provides defense of sorts. The years to come. Alright. Next, we have the Caparo test, also same straightforward, as established in the Federal Court Decision of Tenaga National Malaysia. In order for you to show that there's duty of care, you need to show that there's a relationship of proximity and there is fair. I want to focus on the last two parts. There must be a relationship of proximity and there is fair, just, and reasonable to impose the duty. Why is this important? Recently, there got a couple of cases arising in the courts where, especially in relation to housing projects, purchasers sue not only the developer but also the consultants involved in those projects. So, can they succeed? This is the $1 million question. And this is where the issue of the proximity test comes in. What is the nexus between you? In other words, you have the consultants, you have the developers, and then you have the purchasers. So, in the event a project is carried out, works are carried out, and there are issues within the final product, they're not conforming to specs, or there's a delay in the delivery of vacant possession, can you go after the professionals? Anyone? Can you go after the professionals, the architects, the project, the engineers, the project? Are you, as a purchaser, can you go after the consultants? Can. Okay. They try. I would say they will try. And I have seen scenarios and situations in which purchasers have tried. And you'll be surprised that they know exactly what they're doing. So we have to be very careful. We as professionals have to be very, very careful. They know what they're doing, they come after the consultants also. Why? Because consultants can't run anywhere. Developers at the end of the day, with respect, if things go sour, there is always the option of winding up and then, liabilities against the company, isn't it? Not personally, but as architects, as consultants, as engineers, as QS, we are here no matter what we are here, isn't it? So this is where the proximity test comes in. Do we have proximity with the parties that are suing us, for one? Number two, is it fair, just, reasonable to impose a duty? these are two tests that have come up repeatedly the last couple of years in our federal courts, in our courts. So we'll go through a few key cases here. Alright, next one. Yes, this is the case that I want to look at. It doesn't involve architects per se, but it also encapsulates the duty of care. In the case of Dr. Abdul Hamid Rashid against Jurusan Malaysia Consultants, 1997, what happened here? This was a scenario which didn't involve a housing developer, it did not involve SPA under the Housing Developers Act. What happened here was that there was a house facing the river, caved in due to the landslide. Plaintiffs sued the defendants. Defendants here were CS or civil and structural engineers for negligence. And you know what? The court, as you said, defined this thing called apportionment of liability. Who is most liable? The CNS engineer was 60% liable. Why? Why? Number one, not carrying out proper slope stability analysis. It was bad enough. Number two, using sensory perception instead of measuring tests to reveal soil characteristics. Okay, fine. I will next to this area that is next to a river. Just use the fingers to get the stick. Not kidding. So, of course, at the end of the day, failing to determine the soil conditions to a high degree of certainty before designing and constructing the home. So, in short, due to the actions of the CNS engineer here, in not carrying out proper tests, in not carrying out his duty as one who is reasonably competent in his field, simple 60% liable. So, if you ask me, can a house buyer, an ordinary person, a purchaser, or whoever sue consultants? Definitely can. But again, to be fair, there wasn't a middle party here per se. There's no developer. This was customized. Okay, I approached consultants, you design for me. You're supposed to take into account all these considerations. You fail to take into account these considerations, therefore you are liable. Finish. Simple. So the issue again here was, remember I told you a short while ago, the importance of continuous professional development. One of the issues that was raised here is that as a reasonably competent professional at that point of time, you want to be aware of the latest technologies and so on and so forth, which are used for you to utilize for all the other things. Like for us as lawyers today, I'm just sharing a short while ago, we no longer only have physical trials or court attendances. A lot of our cases as lawyers now is carried out through Zoom, especially the appellate courts. Your court of every and federal court, we very rarely stand inside the sports anymore. And to be very fair, it's a very, very beautiful building. If you have never been there before, the Putrajaya Palace of Justice, one of the most beautiful buildings you can imagine. Very, very beautiful. And we like doing that. Unfortunately, because of technology, or fortunately because of the COVID outbreak, a lot of cases now are all done online. So same thing also, no matter how senior you are as lawyers, as solicitors, now everyone is doing it that way. The late Sri Gopal Sriram himself, we had a age of 80, 70 plus, was carrying on Zoom trials and so on and so forth. And we had to do everything to e-filing, all online and so on and whatnot. This is a very traditional profession just like yours, whereby people want to have a set way of doing things, but we can't. We have to move with the times, likewise here. Alright?
Excuse me.
Yes.
But how is this comparable to the Highland Tower case?
There are similarities here. There are similarities. In fact, I'm going to cover the case of Highland Towers also. So, just to give our a bit teaser trailer of what we're going to cover here. Can you sue a consultant when there is a contract between you and the developer before you talk to the consultant? So, my answer would be, as the voice obviously, it depends. I have to be honest, it does depend. Generally, no, but sometimes yes. When yes and when no. Okay. So let's discuss that. Very good question though. Okay. Now, exactly, we're just talking about Stephen Boss. Everyone knows the famous case of Stephen Boss in Lund. Anyone here who's not too familiar with the facts of the case? Yeah, for the obviously, okay, you may not be so aware of this particular matter. I'm quite sure you all are. This was one of the most tragic disasters involving this country in terms of collapse of the building in Highland Towers, Bukit Antarabangsa. So what happened is Stephen Boss sued, of course, the developer and also the architect involved in the project, engineers, consultants, and so on and so forth. Now, what are the duty of care identified in Stephen Boss case? Number one, this is important. Primary consideration is the safety of the building itself. So in designing the building proper itself has to be safe. We all know that. You don't need that to tell you that. Number two, the condition of the land and vicinity must be considered. As we know, this involves what is the issue in civil court? Basically underground water.
Yes.
One of the key issues is underground water. That ought to have been this. Exactly. One of the key issues was that you ought to have discovered the geotechnical surveys, the geotechnical tests ought to have discovered all the things which you need to do so. So not only do you need to make sure the building itself is safe, the vicinity of the area itself is but consider evaluated if it will affect the building. Number two, by constructing the building itself, how does it affect your vicinity? Because we generally have a very narrow view of things sometimes. We look at, oh, my job is to make sure the building is safe. My job is to make sure the surrounding area is safe in order for me to construct this. We don't talk about at least what we construct there also affect the surrounding area. There is a duty to also ensure you do that. Alright? Yeah, okay. So this is the decision Stephen Port's good. Again here, the key takeaway from Stephen Port's case is that the consultants in this project were held to be liable. Which then some of my clients come back and ask me, but recent decisions of, and to say they are well aware, recent decisions of the court are saying that consultants are not liable to purchases of product. So how do we reconcile these two? And if there is a way we should reconcile these two well, contrasting positions, some may say. How? Now, in the case of Stephen Port Chenglu, purchasers sued the developer and architect for delay in vacant possession. Architect was found to be. Sorry, my apologies. The case of Low complaint against Roger, I'm quite sure all of you as architects are very familiar with this particular decision because it affects your directly as architects. What happened here? Very straightforward. There was an issue regarding the delay in vacant possession. Architects were held to be 50% liable. So, what is the decision of the court, the federal court? Now, a contractual matrix within the developer's purchases already exists. Could be no action if the remedy asked for specifically provided. In other words, purchasers are suing the developer, are suing the architect. Mengapa? Delay in providing vacant possession. As we all know, this involves a contract under the Housing Developers Act. In law, all contracts that come under the Housing Developers Act are special breed of contract. We call them statutory contracts. Why? Because you are not allowed to vary, amend, change, or whatever a single word in that contract. And then you'll be surprised that over the years, if you try to do that. What are the kind of things that try to be varying? What? HDA contracts. Normally we have this HDA contracts and the developers, right? What are the kind of terms that they normally try to vary in the contracts?
Defects.
Defect liability period, DLP, date for delivery of vacant possession, and so on and so forth. And one of your colleagues asked me a very good question before we started. What's the question again, man? Regarding the sales and purchase agreements. Booking fees, we cover that also. She asked me, are you entitled to collect booking fees? Hold on there. The general answer when it comes to HDA contracts is you cannot change a single word there. Okay. Now, that's before we go to booking fees issue. Let's talk about the case of local complaint. Local complaint says very straightforward. You already have HDA.
Yeah, I think this one is not HDA. This one is an industrial project.
Correct.
The vision use it's not the HDA, it's not the housing. Right. They sued them because they didn't deliver the developer couldn't deliver the
One line.
ET on as what they were supposed to do.
Correct.
Due to the developer not buying another piece of land to do a sewage treatment plant. But so it's not a
Yeah, I don't understand. It's not a HDA, it is a contract between the parties. But the idea being that there's already a contract between the parties, therefore, the contract between the parties already provides remedies under the contract. So an extension of that, the current scenario situation is that where you also have housing developers have base contracts, where you already have provisions regarding late delivery, you already have provisions regarding defects, how you sort out, how you tackle defects in those contracts. So in such a scenario, where you already have a contractual remedy as such, there is no basis for you to go after the consultants. So back again to Stephen Port's case, where when we argue, look, how is it that we still have liability of consultants for architects, engineers, or whoever it may be, despite the fact that it's a contract. Now, as long as the remedy is provided in the contract, we go on the contract and sort it out. In the event it goes beyond the terms of contract, for example, negligence claims, your contracts won't cover negligence usually, issues pertaining to negligence. So in such scenarios, if they fall outside of the ambit of such contracts, then you have the right to go after the consultants directly, as it were. So if it is already covered, you don't. If it is not, then you can. In a nutshell. So this is where the proximity test comes in. Right. Again, we also have the but-for test, what we refer to as the causation test. I won't go through that. What it basically says is this: but for your actions, this would not have occurred. And of course, you need to show that there is a nexus, it is not too remote. So your actions from the lack of it has to have a link or a thread between what you did or did not do with what actually occurred, the losses that have been suffered. In other words, what we call the famous wagon mount case, and in Malaysia we refer to the civil miles case. Okay. Right? And lastly, proximity of relationship. This was also covered in the case of KL Ecocity. Now, in the case of KL Ecocity at Taksin Engineering, this was a scenario in which can you go after the subcontractors related in a project? That is, what happened here was this. Here, the subcontracted work or materials do not result conform to the required standard. Can the building owner sue the subcontractor or supplier that they paid? So again, we go by the hierarchy of contracts. So if there is a main con, for example, this employer is the main con, then the subcontractors, and so on and so forth. You can only sue someone, in other words, that you have breach of contract with. You can't sue someone that you don't have a contract with, even if ultimately, because of the breach or because of the negligence of that third party, you have sustained losses. So the correct procedure then will be you sue who you have a contract with, and if necessary, they will then go for another case against that particular party, the subcontracted party, and so on and so forth. So we go by way of hierarchy. We can't go beyond it. If we were to file a case like this, ordinarily the cost probably be struck off for one of locus. That's why I say the first thing, who's the party you can sue, who's the party to be sued. Can you sue this party? You have the right to sue that party. As such. Yes, sir.
The same thing with developer and architect. Buyer should not be able to sue the architect, can it? Because they are not having any contract with the architect.
I absolutely agree. I absolutely agree. But the refinement there would be you cannot sue the consultant or architect directly if the remedy is already provided in the contract between you and the developer. It is a contractual issue. If it is an issue that goes beyond that, for example, the issue of negligence, breach of duty of care. Like for example, the case that we just discussed at the collapse building, so if you have breach of duty of care, the breach of your duty of care is not covered in the contract. Negligence issues. So in that kind of scenario, they may argue that I still have the right to sue them because you have federal court decisions that allow you to sue.
The base is on previous
Old cases, the older cases especially. So the older cases always say that you have the right to go after the engineer.
So the architect you don't contract or whatever to sue the architect, but you based on court decision previous.
You don't use the court decision. The contract doesn't provide you an opportunity to go and get some sort of recourse against the other party. So, give a simple example. Developer, purchaser, consultant. Between developer and purchaser, you have the SDA. Okay, between the consultant and the developer, they have their own contract. So if there's some issue in terms of date delivery, vacant possession, purchasers can sue the developer. Can you sue the architect? Of course not. Even if it's the architect's fault. If it is really the architect's fault, the correct position I would suggest would be the developer has to take a separate action against you, or to join you as a party.
The buyer, but not the buyer.
Not the buyer. But if it is a scenario in which involves negligence, for example, you as the architect have done something so grossly, or the engineer, for example, gross act of negligence, for example, the building collapses within a month of moving in. This is giving a very extreme example. Then in that kind of a scenario, we say that the buyers are precluded from filing a case against the consultants? Perhaps not, because you have civil court case.
Issue of the can be a case for purchaser to directly sue
Possibly, you know why? Because when you talk about fraud per se, it's not an element of area that is covered in the contract per se. When you see fraud, when you see fraudulent certification, how will that affect the purchases?
But we have to pay the bank. I mean, the bank releases the money. Based on the certificate.
Okay, I would argue again that on a factual basis, your LED clauses will kick in, isn't it? Sorry, your DD in vacant possession will come in, no?
Not so much from me, but let's say certain stages were not completed, like the defined or has been completed. Especially for the Singapore project.
Okay, the net effect of that will be delay or issue of quality,
Early release of money payable.
although they should not have been released. Again, I would stand corrected, I would say that you still sue the developer. But at the same time, the developer then has the right to take an action against the fraudulent certification separately. But as I said, again, although whatever I've said here, I have actually had a scenario just last couple of years where purchasers actually sued the developer and dragged in the consultants also and went full and big. Luckily the case got settled eventually rather than for full trial. But they had certain points too. And again, to be fair, this is the developing area of the law, perhaps they could argue that, but I will still stand by my thoughts that there's a separate cause of action by the developer and not so much the against the architect per se.
Yeah, can you say that directly? Buyers and consultant. I mean, buyers cannot sue other the consultant except we talk about negligence. In other elements, there's no way that the buyer can sue consultant.
Okay, I will rephrase it and put it this way. If a purchaser wants to sue a consultant, we first need to examine the contractual matrix. That's why the next few times will go in. You will have a direct contractual relationship with the consultant at the other end. So what you have with the developer. What you're suing them for, is it covered in the contract? If it is already covered in the contract, of course, some lawyers argue otherwise. They say that I have a right to sue in contract and tort. An argument would be if you already have a remedy in your contract, why are you still suing in tort 100%? So then you need an answer. If the remedy either was not provided in the contract per se, then you may go out. So I'm just giving negligence as an example. Hypothetically, let's say it is a cause of action that doesn't involve what's in the contract, and it's not negligence. You could hypothetically do the same too, because it's not covered. The courts are now going to close the door. But of course, it's a no, right? No. But you see, the issue here is this: do you have a nexus with the person you're suing? What's the connection between you? That's why the ingredients for talk to the basic ingredients are very important. Duty of care, breach of duty of care, resulted in loss of damages, and so on and so forth. And of course, the tax has to be satisfied. Okay, again, proximity of relationship. MRCB builders, main contractors sue the subcontractors, engineering consultants for negligence. Again, High Court held the subcontractors consultant had no proximity with the main contractor. Damages not possible. No assumption of responsibility by the consultant. Nexus was solely between the main con and the subcon. Main con, subcon's consultant. Subcon's consultant sues up something of right. Can you as the main con go after the sub-consultant, although it affects you? The correct position would be, well, sub-consultant, whoever you hired on your own accord, on your own choice. So therefore, the correct position will be, I sue you, you then decide how you want to do it. You could, for example, file a separate suit. You could, for example, in court, we have the joinder of parties. What will then happen is that you sue the subcon will then maybe the sub-consultant's engineer team, either the same suit or separate suit or whatever you call it. That can be done too, or to get an order for costs. Okay. So simple. I don't have a contract with you, you don't have the right to sue me. So again, as I said, we talk about complex matters, but it boils down to the basic principles of the law. Again and again. Of course, the famous case of L3 architects against PCP constructors Trevor recent matter also. Main contractor claimed that architects had been negligent in certifying and issued interim certificates. So, question, $1 million question. Does an architect that is appointed by an employer owe any duty of care to the main con regarding payment certification? So, yeah, simple. Architects ought not to be held liable for claims of pure economic loss where a contractual matrix exists between the employer and party by way of a PAN contract. clearly define the rights and liabilities of the parties involved. So again, it boils down to proximity, it boils down to nexus. Employer appoints you to certify works carried out. You do some issues there, the contractor then comes after you, hey, you wrongly certified, delay in certification, whatever you call it, but in delay in certification, you always have remedies under the bad contracts, like if you don't do it, do the next round or whatever you call it. What then? All stuff is the same also. You don't have a contractual relationship with me. So there are two parts here again, let's not confuse it. There's contractual nexus, there is nexus in terms of duty of care. Contractual nexus, you must have a link between A and B. A and B must sign a contract. How they could have worked around this is very simple. They could have had a situation where you have a tripartite agreement. That means employer, what do you call this, contractor, and also the architect sign a tripartite agreement. Then yes, there's contractual relationship, kalau macam tu. But in the absence of such, you don't. So the next question is, if you don't have a contractual relationship, you try to check and see whether they have a relationship in terms of duty of care. Okay.
But if the architect is the FO,
But again, I argue that there's no joint agreement involving them and the contractor, isn't it?
I mean, because being SO, he's representing the developer or the owner.
You could argue agent principle there, but again, we boil down to the same thing. Are you part to a contract? Are you party to a contract between the contractor and the the contractor and the employer?
But in the contract, it's mentioned the SO being you.
True. So you are named in the contract, but are you a party to the contract? So that would be the argument. Just because I'm named in the contract, okay, that's my position. Again, if I have, again, to be fair to the contractor, as far as the contractor is concerned, your job is also you're supposed to be neutral, impartial, and all these things. But at the same time, you are a representative of the client. So your actions, as far as I'm concerned, you have the blessings of the client. So if I can involve the client, then what's the point of bringing up the architect anyway? So that is that would be my suggested position in the law. Alright. Okay. So and again, also very importantly, you already have a PAN contract which defines the rights and liabilities of the parties. So it boils down to the same thing already. If you have a contract that stipulates the rights, contractual rights of the parties, you don't go after them for top lah, or you don't go after them for contract when there's no contract. Falls down to that. Next one. This is another interesting area of the law. Pure economic loss. Can you claim for pure economic loss? Because of Tenaga Nasional Malaysia against Batu Kemas Industry. What happened here was this. There was an issue where the supply of electricity went off for a period of time, resulting in losses. So, for example, you're running a factory. If you're unable to run the factory for a couple of days of this, losses. The other day, now, also 2 days electricity, something where 1 month or whatever you call it. For a couple of days, we couldn't run, use the office. That results in losses to us. So this would be defined in law as pure economic loss. So can you claim pure economic losses? General position in the law is no. Okay. Pure economic loss, independent of physical damage, is not recoverable in claims for damages caused by power failure in construction. If due to the power failure, there is damage to equipment and so on and so forth, if due to the damage, the lapse or the disruption in power supply, you are unable to carry out production, then no, different setting. Which is like this also we saw in one case that we done it a couple of years ago. So just to give a background, there was a housing project whereby the purchasers post delivery of vacant possession sued the developer and the consultants in the project, saying that it did not conform to specs, delay in delivery of vacant possession, all the normal things they went up. One interesting point that they raised was also that there is a breach of statutory duty. My question now, as architects or as engineers, when we construct or assist in the construction of buildings, what are the provisions of law that we need to conform with? Sorry? Standard. The UBBR, Uniform Building Bylaws. So I want to ask you a question. If what what is constructed is not according to the uniform building bylaws, can you sue? They actually raised this issue. Now, Justice Lim Chong Kong, I'm quite sure you all are quite aware who he is. His lordship is a former quantity surveyor turned lawyer and one of the best judges that I've had the honor of appearing before. He absolutely, and his lordship absolutely knows what his lordship is saying in court. In fact, I had a construction matter once where in addition to the questions posed by the lawyers, his lordship actually spent about 5 minutes to 10 minutes asking questions in order to clarify certain areas of the law. And we both the lawyers were looking at each other. Because it involved an issue pertaining to QS, involved issue pertaining to rates and so on and so forth. And that was what happened. And his lordship's final judgment in that particular matter was 150 pages thick. I still keep it in my house, usually. It humbles you, okay, oh, if you think you know a lot, people there will know much more than you. It's a long way to go. So, Justice Lim Chong Kong's position there was this. When you talk about, yes.
You are talking about economic loss. Okay, you are giving example about, say, there is a power cut, then you are being affected, Russian factory, then it damage your equipment. Say you can be claimed or whatever it is. But what happens if that equipment is supposed to come with backup power, but the backup power doesn't work? So is there room for that claim?
Well, generally, again, this general principle of law, we have this thing called the eggshell skull rule. Have you ever heard of it before? Okay. In the event you accidentally hit somebody, and ordinarily a normal person wouldn't get hurt, but this particular person gets hurt. Why? Because his skull is extra thick compared to other people. It's still has an eggshell. The fact that he has an eggshell doesn't mean that you get away with it, because at the end of the day, you take people as you find them. So back to your question, just as an extrapolation, whether or not he has backup, he or she or the company is under no obligation to have backup. It's good to have it, but if you don't, so what?
But
So you
the
take that.
equipment requires that you got to pick up.
Yeah, but if the equipment is not maintained properly, then it's up to them, then the burden falls back on that. But in terms of additional measures to secure and so on and so forth, again, we go back to this sense. My thoughts on that.
Eggshell.
Actions are wrong. You take who you find the way they are. So, but there is a duty to mitigate losses involved. So if, for example, you say that I've suffered damages due to the negligence of another party, there is a duty on the victim or the defendant, the plaintiffs here, to reduce the quantum of damages suffered. If you fail to do so, then the court can reduce the amount of damages more than they have to demand better. So the duty to mitigate. But the duty to prevent acts of negligence against you, I would say probably no. So back again to the breach of bylaws. So we talk about the uniform building bylaws. So in that particular matter that we have, not only did they go for breach of contract, breach of duty of care, and all those things, they also raised an interesting point called breach of statutory duty. They're saying that as architects, you're bound by the provisions of UBDL, whatever you do has to conform to the uniform building bylaws. Correct? Of course. But my question is, which I raised then, even before the decision came out, was this: who are you to say whether I breached the UBDL or otherwise? Similar to local council laws pertaining to the powers of the local council and so on, the one who has the right to enforce such laws is the statutory authority. So don't be very creative, like we need uniform building bylaws and so on, which they did. So that is the position of the courts. When it comes to uniform building bylaws, yes, of course, there may be an issue there, but complaint. At the end of the day, there is a duty of the necessary or relevant authority to take action, if any. It's not for you to claim an issue for contract or talk or whatever you call it. People are very creative, that's why I say nowadays, the average man in the street knows everything there is to know about medicine, knows everything there is to know about engineering, knows everything there is to know about architecture, knows everything there is to know about the law. We have Google, right? Everyone becomes an expert. I had a case a few weeks ago, this is a diversion. Client approaches for issue employment matter. spend 5 minutes explaining to me how he can sue his employer. Okay, about 50% correct. Not too bad. And my family members or doctors say the same thing. They come and see before the doctor and based on the symptoms, I believe I have this. I don't think you are right, doctor. My family members will be studying all these years of the fact, this is why I studied 6 years in medical school. You don't need to get a lecture on what medicine to take and what not to take. That doesn't mean you're always right, but everyone now seems to know something. So we have to respect that. Exactly. So we have to respect that and you have to be careful too. Let's not take things easy when it comes to the ordinary kind of street. Everyone knows their rights to be fair. Whether you like it or not. Right? Yes. Mitigation of damages. Claims of fleet heavy engineering against massive properties. Right? Now, it is a settled principle that the plaintiff is under a duty to take reasonable steps to mitigate the loss consequent to the defendant's law. And you will not get damages with respect to any part of the loss whose due is neglected to take such steps. No worries. I had an example of this happening to me while once I was in the court of appeal. I was 2 years in practice. So even first year of practice, you go for court of appeal, 3 judges feel a little bit jelly. So they started reading during that. I wish the others had followed me there. But I want this. I still remember. I got a small matter, very small matter, but the one is I still remember because it's very embarrassing scenario. This Justice Abdul Sultan Abdul Hamid Mubakar. Have you heard of him before? A very famous judge. Very, very loving gentleman. He just smiled and said, "Nice to meet you." Oh, yes, sorry. Yes, sorry.
So you forgot to continue start what's the decision for Justice Lim Chong Hong?
Definitely Chong Hong's decision when he involved the UBBR was very straightforward in that it is not for the purchaser, this case for the private individual to bring in a cause of action based on a breach of statutory duty. And again, I'm just referring to the UBBR, it could be other statutory duties prescribed under the law. And so on and so forth. So it's an issue of history issue or whatever you call it. It is for the necessary statutory body to take action as such. That was the decision of the statute now.
For that, we should under great judgment.
No, my decision to be that's fine. It's particular decision that the statute decided upon. The case of Care Eco City against Taxing Engineering. The decision is only for the local authority to enforce the uniform building bylaws. It's government if a breach of bylaws will give a right to a right private action. So the local authorities will come after you for UBBR breaches, but not for you as a private individual to bring in a cause of action on basis of breach of UBBR, alleged breach of UBBR, and so on and so forth.
What happens if the local authority gives a waiver on that particular requirement of the UBBR?
Then even better, because it means that there is, I hypothetically say, the only one who can take action against you is the local council. So the local council itself says that issue, no problems. Then who are you as a private individual to bring in? As I said, people are trying to be creative right now. Okay, which you got contract, which you got top, which you got UBBR. Something sticks on the wall there.
But what if your failure to adhere to the bylaw leads to tort?
Well, I would say your failure, your cause of action in tort would arise again with or without the breach of the UBBR incident.
Okay.
So the subset, the main thing would be there is an issue regarding negligence, cause of action in negligence, and among others, it also results in a breach of the bylaws. It's not because of the breach of the bylaws and negligence. Okay. Okay. So far, okay. Para you kan. Saturday morning, I totally understand. This is true. Okay. Now, I'm sure you all know about the law of limitation. As far as it has been over the years, how many years Limitation? Again, we'll use the famous word lawyers use. It depends. It's not always 6 years. It can also be 3 years. In some circumstances, the Government Proceedings Act is only 3 years. In some circumstances involving accidents, negligence matters, involving accidents, it's not 3 years, it's not 6 years too. There is a particular timeline when it comes to taking action, and there have been cases where it's struck off by court because you fail to take action within the time. So, but insofar as we are concerned, for contractual matters relating to tort, it's always been 6 years. But there has been a weakness in this law, or unfairness in this law, so call it. I'm quite sure you all know that what are latent defects. What are latent defects?
Things you can see,
Sorry?
things you can't see.
Things you can't see with the naked eye. So you purchase a house. After a period of 7 years, you suddenly discover problems. There was one case that we dealt with whereby there was honeycombing in the concrete structures. Would you be able to discover it within a period of 6 years? Doubtful. You never know. You never know. Again, I was waiting for someone to say the word. Yeah. So it depends. You may not. Usually something else happens and you discover it over a period of time. So what happens after the 6 years? Unfortunately, you can't because your cause of action limitation applies. 6 years, that's all that there is, and it's very strict. In fact, countless cases, people trying to bring cases to court after the statutory limitation period. Okay. So this is when an amendment to the law was made. Under Section 6(1)(k) of the Limitation Act, any action must be brought within 6 years. Okay. The 6-year limitation period, regardless of when the plaintiff discovers such damage. This is the case of Hamlet based on the whole case. So whether you discover 6 years, 7 years, 8 years down the line, that's all. But there was an amendment to the law under Section 6(a) of the Limitation Act 1953. What it says is this: you have 3 years from the date that you discover the defect, and you have a long stop of 15 years. Okay, sounds a bit technical, right? Let me break it down in a very straightforward and simple manner. Because even for us, sometimes people say, a couple of hours to say, how will this actually work? Now, what it means is this: let's say you purchase a house in the year 2000. There are latent defects in the walls and so on and so forth. You only have until 2006 to file a case. Okay. Let's turn the scenario. You purchased a house in the year 2000. In the year 2007, something happened. Cracks started appearing in the wall. You then bring in an expert. The expert comes in, carries out whatever he has to do, whatever tests he has to do. He identified, or she identified, that these defects actually started from the very beginning itself. So what does this mean? That means in 2007, you have 3 years within which to file a case. So what happened in 2000? The defects began in 2000. You discovered in 2007, by right, no longer protected. But because of the amendment to the Act, now we have 3 years from 2007 to do something. Of course, after the 3 years 2010, you still don't do something, you're out of time. So the second part of the law, the 15-year issue. What the 15-year issue backstop means is this. Now, you purchase house in the year 2000. You discover cracks on the wall in the year 2015. For 2016, let's say 2016. And then you bring in an expert. Expert says it started in the year 2010 onwards. The stuff that they use, material that they use, the raw material that they use, concrete that they use, whatever it is, was not what it's supposed to be. Below the standards expected, and so on and so forth. Now you're out of time because the maximum period is 15 years from the date of occurrence. So this happened say in the year 2000, so 2015, you're out of time. That is the amendment to the law. Again, there are some solicitors who believe that the wording of the Act itself is a little bit, it's not very helpful. And we haven't got any claims under this yet at the moment. But it basically opens the door for latent effects in years to come. How does this impact us? They can come after us even after many years. But there is a hand effect of such things. So even if they go after the developer, or in some cases where there's a contract directly between you and client, it no longer ceases at the point of 6 years. It goes on. And you know what's the most important thing? It is not limited to latent effects alone, If you read the act, what the act says, except for personal injury. Except for personal injury. So section 60 amendment says that except for personal injury, this new 3 years and 50 years regime comes in. So could we definitely could you be waiting for negligence? Yes. It does not necessarily just involve the construction industry. If you want to take a very generous reading to the act, it could involve other professions also, but not personal injury. Personal injury, for example, there's a watch during a medical procedure, that will be personal injury. There's an accident, someone gets knocked down, suffers brain injury or whatever you call it, then it's personal injury. So we are talking about non-personal injury based claims. So you have the 3 years plus 53 years. So what is it? 15 years. Within that 15 years period, 3 years of the date of discovery. Anytime within the 15 years. So, food for thought for all of us. We lawyers and doctors in.
Scenario for you.
Hmm.
Okay, let's say you purchase this house in 2000 year, then you discover water leakage in 2002, is 2 years after you taken possession. Then you complain to the developer, let's say they come in to rectify it. And then after that, you stay at house maybe 10 more years, then it will occur again. So how do you interpret using this limitation?
Okay, you go back again to the works that were carried out by the developer.
Yes.
Did they truly fully fix what they were supposed to do? Or was it just a stopgap? They just exit plastering over the cracks. Literally, like to use a term that you want to use. The cracks are still there, just put a plaster over the cracks. I didn't fix it. So again, it depends. Unfortunately, I haven't said that. But the argument would be, did you do what you're supposed to do? When did you fix it? So you fix it 2 years later. So I'll say your fix itself is wrong. So I'll start again from the fix. My argument would be that factual basis. Yeah. Any questions? So far? Yes, sir.
So you're talking about the issue of during
Yes, sir.
the no limit of time limit. Let's say the person suffer injury, the 16 years or whatever, but still the effects of building can still, I mean, the parties involved still possible to be sued.
Okay, when you say injury, I'm talking about personal injury, so effects.
The injury, let's say we
Collapse.
fall down and hit somebody.
Okay, good question. Again, when we talk about personal injuries arising from a building, it is a good question actually. I need to consider that. We put it this way, if a personal injury occurs today, you have 6 years of duty to file a case. The scenario that you are saying is not covered under the Litigation Act.
Yeah.
I would argue that even if, again, my thoughts are not necessarily legal position would be, even if it happens after a period of 15 years, but the reason that it happened was because of an omission of your part. Perhaps it could still go operate because the 6 years starts from the date of injury occurring. Again, this is my personal thoughts on the matter.
So you mean it's not unbound?
I wouldn't say it's not time barred. I'm just saying that in filing a case for personal injury, you are time barred within 6 years from the date of the accident. So then your issue would be to show that this resulted from a negligence or omission that you or the person carried out all those years ago.
15 years ago.
Yeah, possible. See, again, as I said, the wording of the law is a little bit I wouldn't say convoluted, that's how it's worded. So it opens the room for a bit of interpretation that there are areas that, if what you say, the scenario, that could happen. Yes, sir.
Normally for building collapse, it won't be from like perfect building, no cracks or anything, and suddenly the building just collapse. Usually, I would say that will be on the part of owner as well, whereby they did not upkeep their buildings, whereby there could be cracks and all that, and they couldn't bother to fix it up. So that could be a very well negligence of it.
I totally agree. So again, he who asserts, as we say in court, he who asserts has to prove his case. Under the Evidence Act, you have to show the causation. Remember the basic evidence that I showed is not. You have to show that this building collapsed only because he acts the consultants, or at least that needs to be proven. So as you know, buildings after a period of time, the issue of wear and tear, lack of maintenance, all these things comes into being also. So the burden to prove that it's because of this whether that this happened, this check that it happened, falls on the person that is suing in court. Can they do that? Can you get an expert who's going to come in and say it's only because of fault of the consultant? If you're talking about, for example, Stephen Ford's case, Highland Towers, quite straightforward lah. You know, underground water, what would the buyers have done, what would the purchasers have done? But in scenarios involving well, issues, structural issues, and so on and so forth, how do you do it? Can you do it? If you can, then perhaps. So the burden is on you, it's a heavy burden. In court, we have in law, we have two things, we call it the standard of proof, the burden of proof. The party asserting something has the burden of proof to prove it. Of course, for civil cases, it's on balance of probabilities, the standard of proof. Does that answer your question, sir? Sorry, sir, you had a follow-up question, yes, sir?
Okay, if you take that case, what you are explaining just now. Say if you have an employee specialist in order to determine the fault of that particular failure.
Yeah.
So if you want to take action against the consultant and you win the case, can you claim that consultant fee that you charge the specialist as well?
We normally do claim for that also. In our damages against the other party. I'm talking about civil cases, we normally do that. The cost of preparing expert reports, this will come under special damages, we will. That will be that. Okay, well, yeah. Okay, does anyone, can we take a short 5 minutes to read?
Yes.
15 minutes very long.
Maybe start.
So Saturday morning some more. Thank you. Is it sweet?
Yeah.
Alright. Thank you for the patience. Now, the next part of our seminar will cover navigating legal challenges in contract, letters of appointment, recognition of oral contracts and WhatsApp contracts in Asia, recent developments of legal contracts in information law. Alright, legal contracts. What are legal contracts? Now, the provisions of the Contracts Act is very clear. We have sections 10 and sections 24 and section 25 of the Contracts Act. Section 10 basically says this: all agreements are contracts if made by the free consent of parties completed the contract. They have to be, of course, not a minor. Lawful consideration and the lawful object and not hereby expressed to be what? In essence, for a contract to exist, offer, acceptance, intention to create legal relations, and of course consideration. Just as he taught, for us to attack an issue of contractual claim, if one of those ingredients are missing, there is no contract. Simple. If all those ingredients exist, even if the word contract is not used, it is still a contract. Okay. Now, what are illegal or unlawful consideration under a contract? In short, if the consideration object of an agreement is forbidden by law, very straightforward, you are dealing with something that is inherently unlawful, such a nature that would defeat any law. For example, you come up with a contract that is designed to avoid paying certain taxes to avoid paying certain amounts of money to the government, for example. This would then amount to a contract that is designed to defeat particular law. Thirdly, fraudulent contracts, of course, or implies injury to a person or property, a contract to hurt somebody. Of course not. Lastly, if it regards, the court regards it as immoral or opposed to public policy, which again, public policy is not a closed category. Numerous contracts are deemed to be, can be deemed to be against public policy. So whatever is not, okay. And thirdly, if each of these cases consideration object agreement state to be unlawful, simple position in law. If a contract is unlawful, the court cannot enforce a contract. Simple. That we see the extreme position taken by the courts over the last couple of years. Two cases. The famous case of Baru Mahawangsa and of course Lead Kavi against law for this. Baru Mahawangsa was a very important federal court decision. This involved, as you know, have you heard about the crooked bridge in Johor? There was an effort to build what we call as the bridge connecting Singapore, Malaysia to Singapore. Of course, the design of the bridge is supposed to be crooked in nature, and then 60 to 600 and then reaches Singapore. So very well. So there was a proposal for this particular project. Ultimately, it was not built. Now, the issue that then arose is that for this particular scenario, there was for a party that came in the middle, claiming to be a consultant, saying that they could get this particular project if they pay certain commission. Consultants are they, in other words, to pull strings or get things done. So what happened in this particular case was very simple. Key decision is this: courts are bound at all stages to take notice of legality, whether or not pleaded and to refuse to enforce a contract. What the court does in this particular case was very straightforward. In that, a party coming in here saying that they can inverted commas, pull strings, get things done is inherently opposed to public policy. In other words, you tender, you do what you need to do, you get evaluated, you get awarded. That's all. It shouldn't be because you know people. In other words, this was a monumental decision. Because in this particular case, the consultant came in and made a claim against the party that was supposed to be awarded this project. The project was later cancelled. So the project was actually awarded. So they said we got it because we managed to get you the project. So they come back and say it's legal work against public policy. So it is a very detailed judgment. We have the time, we can share the judgment with you all too. And again, whether the illegality is raised against apparent, it's a duty of the court to take it up and reference to section 4. Why is it important? See, as when you attend or appear in court, you have a case in court. I'm sure you all have heard of statement of claim, defense, and so on and so forth. Now, these are what we refer to in law as pleadings. If you don't say something, if you don't plead something, you cannot easily read the trial. That means you are bound by all four corners of the pleadings. So if you allege, for example, there's issue of breach of contract, you can only talk about breach of contract. You don't bring up anything else, you cannot talk about the other things. For example, breach of statutory duty or whatever you call it. But interestingly, for illegality, even if you don't plead illegality per se, this particular decision says that the court can take into consideration issues of legality. Of course, the real position is a bit more nuanced, a bit finer than that. But general rule is once something is held to be illegal, there's a stage, one drop of illegality, whole contract cannot be enforced, court cannot enforce agreement. That is the general position, very, very draconian, you know. So after this decision, the moment I've had a few cases, we argue legal contracts and throws the two. Courts don't touch already. The courts cannot be party to a legal contract. And also the previous federal court decision in Lim Kavi against lower parties, the court will refuse to enforce the contract at any stage, irrespective of whether illegality is pleaded or whether the contract is expressly illegal. So this is the draconian position. So there's a contract, something is illegal in the contract. But this raises a lot of issues. First question, as architects, you all have a minimum scale of fees, isn't it? What happens if we charge below the fees? Is it right?
Technically,
Technically, if you look at what is the written word, it's not right. You're not supposed to do that. So in a contract where you charge below the minimum fees, would it mean that the contract is illegal? Because you see, and this is what happens. If a contract is illegal, parties, for example, there's an illegal contract. You have paid certain consideration under an illegal contract. Matter goes to court. Whatever you have paid will not be returned to you. because contracts are enforceable. You can't ask the court's assistance, request the court's assistance to assist you because it's a legal contract. There's a draconian, very tough view of the law. So what about us? We charge below the standard prospect fees. So then we had a very important decision in the UK called Patel against Mirza. So they said that a claimant is not prevented from enforcing his claim, even unless, of course, his claim will be contrary to relevant public policy or disproportionate. So just because the contract is illegal, it doesn't mean that parties under the contract have no remedy automatically. Because the original position is once the contract is legal, nothing, you cannot claim anything under the contract, you cannot demand anything under the contract. So the case of Patel and Mirza, although in the UK, has ramifications in Malaysia, a few cases. Post Patel and Mirza, we had the case of Tan Kim Chong, whereby they say okay, we all know the contract may be illegal for whatever reason, to in furtherance of an illegal act or whatever you call it. Here, the court will see whether or not the policy can undermine effective before striking down contracts. So in this case, there is a winding up on the ground of illegality, even if the criminal penalty is imposed. In other words, to keep it very short, very simple, just because the contract is legal doesn't necessarily mean that the court will not extend reliefs to the parties more. So that's the current position in law. Further, in the case of public bank against liability, this involves a scenario in which there was lack of intention on the part of the appellant here is a mere financier. So in other words, you are a financier bank. You need to identify what purpose the money that you are financing for is going to be used. If you extend financial facilities for a particular scheme, is it up to you to make sure that it's only for legal purposes? Despite all you people can still do things you want, isn't it? Something along the line. This involves the purchase of native land, which you're not supposed to purchase, so on and so forth. Okay, but for us as architects, it's professional, while it's applicable. The next case of hardy development. Everyone heard of this method before 2020 decision? Okay, the case of hardy development. Okay, the question that arose here is this. Does the engagement of an architect become void and enforceable for illegality, non-enforceable, if the architect charges professional fees below the minimum fees in the scale of minimum fees? The court held here this. It does not invalidate or render the architect's service contract or engagement agreement unenforceable, thus depriving the architect of any entitlement to recoup fees or compensation. So very fantastic. First you ask for a discount, I give you a discount. After you give me a discount, I press back and say, illegal contract. Cannot enforce. So I don't need to pay you. Alright? That's what they do. So what they're saying is this, yes, it is wrong. It's not right. There is something that says you cannot do this. But is it illegal? And even if it is illegal, we go by the case in Patel against Mirza. The previously very tough approach of the court, suppose has to be refined. It's not automatically cannot claim anything. Because sometimes very straightforward, I have a method. The moment there is legality, it goes at all. They don't go for trial also. That's legal. In the current position in Patel and Mirza, probably the decision would have been different already. So again, what is the takeaway for us as for the architects here? Just because below, I'm not asking you to do that, you all know what you need to do, but just because it's below this prospect fees doesn't mean that contract itself is illegal. This is the decision of the court.
Yes, sir. So we talk about what we call it fee cutting. Now, so that is if you use the PAM form of contract. Okay. What happens if developer decide not to use PAM form of contract and have their own, and the architect agrees on it and negotiate for agrees on the fees and put it in the not a PAM form. Where does the legality stand in terms of the architect? If that's your appointment with the contract.
Well, the main point is, regardless of how much you charge them, as long as you agree to these charges, you have a right to enforce and claim those fees if you have done what you're supposed to do. So just because it's below a particular threshold, whatever threshold, minimum fees, it doesn't mean that it becomes a void contract. Of course, again, if as all of us are members of professional bodies, if there are fixed stipulations as to the minimum fees that you must charge or what to charge if you don't, it becomes an issue of perhaps a disciplinary issue.
Okay.
As such.
We had one case, that's why I asked. And then the one part of the case was that because the agreement is not based on the pen form of contract, it's sort of below the minimum COP, so they consider the agreement invalid. Pandai lah, but we want the case lah.
Fantastic, well done, John. Also, as a side note, again, this is perhaps not so much an issue involving architects, but for us as lawyers and solicitors recently, there have been some surveillance from the PEII, Personal Guarantee Insurance, whereby they say, or this, what we understand is that if you were to charge below the minimum prescribed fees, issues of negligence arise later, coverage may be an issue. So,
You mean insurance coverage?
yeah, it might be an issue. So far, I don't know, I don't think it's been tested yet, I stand corrected, we may not know, this is the issue between them and insurers, but this is what has been stated. So when you give a discount, these are considerations that you need to take into account.
That means before you go for that discount, you have to discuss with your professional insurance.
I think insurances, again, I don't speak for them, but I think the insurance's position is that you have to do things the way you're supposed to do it. If you don't, then we're not going to cover you. This is my understanding. So food for thought, I suppose it would apply across the board. So something for us to be also cautious and wary about.
So the insurance can withdraw the coverage for a case if you don't use.
Again, I can speak to the insurance, it is my understanding that this can be an issue. So something to be careful about, to be wary and consider. At the end of the day, we follow what we are supposed to do, then it shouldn't be an issue. Okay. Now, next, one of the key issues always asked by our clients, I received a notice of demand, letter of demand, what do I do? What do you do when you receive a letter of demand? Right?
Consult lawyer.
That's all. But you see, again, I had clients, or we've had people approaching us, letter of demand is sent. We don't do anything. What happens if we don't do anything? Possibility. There are cases on this also. The moment you get the letter of demand, first of all, don't panic. I mean, it happens. If it's a contractual claim, okay, fair. If it's a negligence claim, not so nice, never mind. If it's a negligence claim, of course, you have got your insurance, inform them immediately, without don't delay. If you have a contractual issue, approach a lawyer, speak to a lawyer, or whoever it may be. Now, letter of demand. Does it need to be just through formal correspondence? No, can even be through an email, can even be through WhatsApp, whatever you call it. Now, what happens? Normally, letters of demands for two things are either they ask you to pay money or they ask you to do something or don't do something. Now, is a letter of demand the same as the notice of demand under section 466? I had a client asking me this just 2 weeks ago. 466 notice is a winding up notice under the winding up policy. Okay, so this is what we call the Companies Act. So a statutory notice of demand under section 466 of the Companies Act is a statutory winding up notice. This one within 21 days, you have a period of 21 days within which you have to pay a debt, within which you will proceed with a winding up petition. This is not the same as a letter of demand. So be very aware. And again, they don't need to say statutory winding up notice under section 466. So you got to be very careful. But normally, a 466 notice is preceded by a court judgment or an award. Not necessarily arbitrators award, but a CIPA award. CIPA award, by the way, is grounds enough to proceed the winding up petition. So you're aware. You don't need to register the award before you can enforce it as a winding up petition. By way of a winding up petition, we'll cover this later. Okay, so be aware whether it's a letter of demand, whether it's a 466 notice. Yeah? What happens if you don't reply? Okay, it's prudent to immediately seek advice from a lawyer, solicitor, where there is no specific legal requirement. The effects of a non-reply may be severe. Depends. Is it a civil dispute? Is it a commercial dispute? What's the difference? Civil disputes involve scenarios involving, for example, contested bill, fraud, and so on and so forth. So, if you don't reply, does it mean you're happy? No, not necessarily. But if the matter goes to court later, what happens is if we weaken the defense at trial, could persuade the court in determining which different version agreement should be. You will see A, the other side will see B. Then the other side's lawyer will come to court. If you see this, why didn't you contest it the moment you receive a letter from the other side? Why you keep quiet? So it weakens your defense, but doesn't mean a fatal blow. But if it is a commercial claim, dollars and cents involving a company, this is very serious. SME Development Bank Malaysia, 2016 case. Any commercial disputes, non-payment or sums due and owing, the repercussions are severe. Courts have even granted summary judgment without full trial. So there's a demand for a sum of money to be paid, 2 million, 3 million, 100,000, 10,000 million. Immediately make sure that you get legal advice, whoever it is, and put in reply. If you do not believe that, say, that is justified, without basis. Failure to reply as such. Why? Because this is very important. In commercial cases, courts have taken notice that if one man of business says in a letter to another that is agreed to do certain things, a company or whatever is for it, the person who receives the letter must answer if he needs to dispute. Simple lah. Someone says, please give me 1 year again, breach of contract. No, I didn't breach the contract. In fact, you have not done what you're supposed to do. I put a counterclaim against you. So your failure to do this can be very severe. That doesn't mean if it's not commercial, you need to reply lah. Just saying that if that's you must reply lah. How can people make things against you just like that? We have our professional reputation, our pride, so it's in what we do. If we feel it's not justified, it's not justified. You have to go out of that. Of course, you think a lawyer, the FT 555 in my defense before I was a lawyer, I worked in a different area. I used to be a R&D engineer before this. Totally different field. Okay, thanks. Your contract has a damages clause. Most contracts have a damages clause. Do you need to prove the damages? Do you need to prove your damages? Previously, that was the position in law. Okay. Let's say you have a LED clause in your contract, liquidated asset damages clause. Let's say you have some sort of damages clause in your contract. The previous position in the federal court was that it is not enough that you have a clause for damages, you also need to prove damages. When I say that my damages clause, if you do this, you have to pay damages of so much to me. I also need to prove that I have sustained damages of so much before I can claim against you. In the federal court decision of Q electronics, however, there has been a change, a big change. You don't need to prove damages or losses before you can claim damages or losses in the contract. What you need to show? Is there a breach of contract? Number two, that the contract has a provision stating that the amount is payable upon breach, but you cannot claim above that. So if your actual losses are above, let's say you have a damages loss for say 2 million ringgit. If your actual damages are paid beyond 2 million ringgit, you can't apply. Okay. So for the other side, those days they will come back and say the principle of law for damages is that he who asks something has to prove it. By now, there's no longer the thing. I show there's a contractual term that you agree to it, that's all I have to do. So you as the defendant who's contesting it, only way you can contest it is by showing the court that now you have to show that the damages was unreasonable. My total consideration under the project is 40,000 ringgit, your damages cost is for 1 million years. And maybe you can argue that it's unreasonable cost. But again, courts will come back and say they uphold the bargain. We don't have an unfair contractual terms act like some other jurisdiction. So if a contractual term is unfair, it's unfair. Freedom to contract. And do remember, this is very important. Just because a document doesn't have the word contract doesn't mean it's not a contract. For one. Side note, you all have heard of memorandums of agreement and memorandums of understanding, right? Which of it is binding?
Agreement.
Understanding? Can an MOU be binding?
Can.
Yes. Can, possible. If the intention of the parties is to be bound, even though it is named memorandum of understanding, named by parties, there are cases of this too. Why am I using this and saying that? Don't assume just because it doesn't say contract, it doesn't mean that it's not binding. It can be binding. Another one, we have negotiation between parties, right? At the bottom we say, negotiate between the parties, send emails to each other, subject to formal contract being signed. Does it mean that there is only a contract once a contract is signed?
No, come on.
I know what I'm going to say now, right? Yeah, the word subject to a formal contract being signed. The word formal or subject contract is signed does not necessarily mean there's only a contract where formal contract is actually signed. Because again, we go into the intentions of the parties, number one. Number two, if the terms of the contract are so voluminous in nature, let's say it's a 30 or 40 page contract, both solicitors or lawyers or both sides or whatever agree with all the terms of the contract, everything about it just need to just put a signature there. Because we consider that the contract is already been signed. Why is this coming? Simple example. When they're negotiating, everything is fine, all of them are all done about it. Suddenly a better offer comes in. Before they actually put the signature on the document, they try to easel out the agreement and go to the third party. The fact that you pretty much agreed to the terms of the contract made by you. Because we go back to intention of parties. Remember? Offer, consideration, intention to create legal relations, and of course consideration. There must be something. I cannot give you something for free much. You must give me something return. Services, goods, payment, whatever. So that's that. Why is it important to us? Contracts through WhatsApp. Can you have a contract through WhatsApp? Yeah, it's a way. Now, now, in the case of young Kong Sing, this was an older case. The case when we say you send SMSs to each other, you all remember those days. Okay. Now, electronic message such as an SMS, okay, under Section 8 of the Evidence Act, although short, reflected the intention of the parties clearly and unambiguously. If, for example, you're talking about supply of goods, purchase of goods for project, and so on and so forth, the exchange of SMS conversations between parties can amount to a valid binding contract. Extension of this is WhatsApp conversations. The famous series of mock check against SOHO, tweeters and emails or WhatsApp conversations. Why? They are in fact given great weight because of the contemporaneous, I think word for instant at the moment, contemporaneous nature of WhatsApp messages. Okay, emails can also be used to corroborate the oral testimonies to witnesses. Okay, a slight diversion. Remember, I told you a while ago that contracts do not necessarily need to be, written as contract in order to be binding. Let's say you don't have a contract at all. Can you still identify that there is, okay, for example, there's a project between two parties. There are POs, invoices, and so on and so forth. Can we still see that there is a contract between the parties?
Yes.
Okay. The written documents, correspondences between the parties as a whole can be deemed to be a contract. I actually had a SIPA matter of this once a couple of years ago. They don't have a formal contract, but the fact that they exchanged emails with each other, the collection of emails was held to be in total a valid binding contract between the parties. But of course, it's better if you have a proper contract because then your rights, your leaves, your remedies are all written down properly. Otherwise, that's how it goes up. Contact of parties also. Quick question before we move on to WhatsApp. Oral contracts are they recognized in Malaysia? Check out below. Can you look? Is it recognized as a contract in Malaysia? Yes.
Yes.
But for purposes of SIPA, you cannot. It has to be a written contract. Or SIPA has to be a written contract. Of course, if in furtherance of the oral agreement between the parties, you have a few SMS, emails, or whatnot, then maybe you can argue. Oral contracts are recognized in Malaysia also. So we very. So going back to WhatsApp conversations. So here, in fact, they say WhatsApp conversations carry a lot of weight because at the moment he gives an offer, okay, I'm willing to sell you this raw material, cement or whatever for this particular price. Okay, okay, I agree to this price. Instantaneous. That is your intention at that moment. So on my contract. Can't run away, Nobody gets worse. Now, the case of Muhammad Azhar, but however, before it gets worse, what is the requirement? This is where I say, one of the parts of this presentation is also about best practices for you. If you have WhatsApp conversations between yourself and supplier, vendor, or whatnot, best thing would be formalizing through formal correspondence, letters thereafter, email thereafter, put it on in black and white. But even if you cannot, please save your messages properly, back it up. So again, just to show this is a practical example because we face this in court. We have the WhatsApp conversations, right? Don't just snapshot the WhatsApp conversation alone. Snapshot the WhatsApp conversation, show it in terms of a running conversation. That means the first page. Then the second page, they must show the continuation. The bubble two continues to the next page, the third page, the fourth page, all the way. So this we can see what this is one part, then there's a middle part missing, which is purposely take out. So show a flow. Show. Number two, we need to show what is the date of the messages. Number three, very important, you must show who the message comes from and the phone number. You spoke to somebody else, not to me, you know. My phone, they were down to court. I'm sorry, my phone, all the messages are beyond already. Okay, so it's only you, so you have to keep your phone and also keep your phone. Because normally you bring the phone that you otherwise you reach out and then you have what we call a section 90 certificate, a printout from a computer document. But you must have this, otherwise not applicable, you know. So if you're communicating actively within your group for the construction project or whatever, semua kena simpan. Jangan simpan dalam phone. Suddenly your phone money masuk air or whatever. Never back up. We're all busy lah, sometimes we forget to do things in the day, so make sure you back up. Yes, sir.
If you discuss over the phone, you discuss whatever you want to discuss, what stuff or whatever it is. And that's it, you stop. Then after you could send WhatsApp to him what you discussed, but he didn't reply. Say yes, agree or whatever he did. That is your side of the WhatsApp to him to confirm what you discussed. Where does that stand?
I'll just put it something, if you don't say otherwise, I did it and you accepted what I said.
I mean, you have to put that.
Yeah, okay. And lastly, the case of Southwest Dominion, this one I have actually had a case of this. Can a thumbs up become an amount to an acceptance of contract? Thumbs up emoji, you have emojis, right? Okay, I agree to supply you 2 tons of cement for this particular contribution price to be delivered on this date. Thumbs up. Okay. Okay, very binding contract. I actually had a case that it just said 2 months ago. That was even worse. The other party had carried out certain works. Okay, not a construction project or some slightly differently. Had carried out certain works. This party claimed that no, I didn't ask him to do anything more, I asked him to do once I pay him. But when he did all these works, thumbs up, oh, okay. God, your thumbs up amounts to you agreeing to him to carry out the works on your behalf, which I think is a very generous interpretation. But this was the interpretation of contract. So thumbs up in contract can it amount to an affirmation of contract? Of course, this is a Canadian case. But trust me, I have had a case just a few weeks ago. I don't think it's going to be published because sorry, a session scored that. If it is published, I'll share the case with you. So I asked again, why you give thumbs up for what? It's just a good time you do, you know.
If you publish it,
Thumbs up against various interpretation also.
Yeah, well done, you're doing a good job. Is it giving a job again? So no, if I did all this work, if you didn't agree, you should jangan buat lah, jangan buat untuk saya. After you bought the diri, you sendiri and you for yourself, nothing to do with me, you know. No, you thumbs up. Thumbs up needs to be. But even better, oh, you're doing a great job, please stop. Moral of the story, got nothing better to say. My mother always tell me that even in fish, whenever I get caught, he doesn't open the mouth. But if he's doing something, put it on paper. Hey, look, you want to do this work, you do on your own risk. I never agree. But again, remember, offer percent acceptance. If I offer to do something, you have to agree to it. Lack of acceptance does not amount to a very binding contract. And if I turn back and say, hey, 50 ringgit is too high, it's reduced to 20 ringgit, then there is not, there's a counter offer already, and so on and so forth. But moral of the story is,
What about noted? You just put noted.
I haven't got a case where I say, let's say the thumbs up. If I get a thumbs up, I say good for him. I say now good for you, you are admitted and you because we argued that there was no contract. He did all the legal arguments, one thumbs up. Just one thumbs up, the guy spent 2 pages asking what the thumbs up. The fact that there was a thumbs up, he could have done other things. I mean, like, see, the thumbs up is worth a lot of money, Okay. Dispute resolution methods. How do we resolve disputes? What's the best way to resolve disputes? The best way to resolve disputes is not to take an adversarial position to settle things amicably or a nice day. Let's decide. I always take the position that I always advise my clients, if you can, you don't go to the courts, we don't set education, we don't go for arbitration. To which my fellow lawyers will say, are you sure you agree? I agree with this, I totally believe in this. Because at the end of the day, once you step into battle, you must have the stamina, the endurance, the strength of will to take it all the way. I was speaking to a gentleman just now who he said it was part of a very important case that affects all of us. Then what the sacrifices, the financial, mental stress, whatever it is that you have to go through is severe. But once you decide to go to battle, go all out. Don't give a chance to yourself. You avoid the threats if you can. No one wants to fight, but once you do, you have to take it very, very seriously. This is one thing I really marah my clients, we don't take it seriously if not. Because it is a battle. Okay? So what are the methods of resolving your issues? Mediation, expert litigation, adjudication, and arbitration under the conditions of Contract 2018 best practices. I'm quite sure you all are very familiar with the provisions of the PAN 2018. Now, these are methods of resolving disputes under the PAN contracts. We have clause 34.0 mediation, clause 35.0 expert litigation. This is new one. Previously in the PAN 2006 added. Have you done that? So litigation added. Good. Clause 36.0 adjudication and clause 37.0 arbitration. Okay. Notice the words may and may there. Now, generally, for lawyers with this thing called escalation protocol. Sounds very cool. It basically means this. Before you take the next step, you have to take a prior step. So, under the PAN contracts, mediation and expert litigation are not mandatory, which means that before you proceed to adjudication, before you proceed to arbitration, must you mediate. That means if you don't mediate, cannot. Okay. Mediation is need. Expert litigation too may. That means it is not compulsory. But adjudication before arbitration is a must if it has not reached the stage of practical completion. So if the project has not reached the stage of practical completion, your avenue then of course has to be adjudication. You can't jump to arbitration anyway. Okay, so that's that. Now, the case here, the case of Joanna Sara Alpha Rich 2015 matter before the courts. Mandatory escalation protocol provisions must be complied before commencing arbitration or litigation. We have had cases where in the contract they say before, for example, your PWD 2038 contracts. Okay, you have this thing where you have to refer any disputes to the SO before you proceed to the courts or arbitration. What happens if you jump, you know, but those go for arbitration? The courts will hold that what you doing is incorrect, and your proceedings will be considered to be null and void. Alright? Likewise, under the PAN contracts, if there is a requirement for adjudication, you throw to be no but go for arbitration. Cannot. Yes, sir.
The PAN education is not by default, it is the AIEC.
Very good. We are going to cover that actually. There's an issue there too. You're right. You see, okay, I'll cover this in the next slide. Okay, but you're right. Is it a bit? Okay, let's put it this way. How you do it is an issue, but you have to do it before you proceed to arbitration. Because you have CIPA adjudication, you have PAN-based adjudication. So how? So that is your question, isn't it?
Yeah, the AIEC will overrule.
Agree. That is the condition. We'll cover this in a short next slide. Thank you for the question, actually. Okay, mediation. Now, what is mediation? Adjudication, arbitration do not require carrying out mediation as a precondition. Any disagreement may be referred to by mediation by parties. This is what we call as a non-adversarial way of resolving disputes. You get a third party, a neutral, independent third party, try to settle things nicely. This is a data approach. Singapore, let's say, sit down with the mediator, try to settle things amicably. Okay. The issue then again will be how do you get appointment of mediator? You go through the president of PAN. Okay, they will informs the mediator or suggests the mediator to agree with the parties. So again, is the decision binding? No, it's not. So mediators play a role in trying to resolve the matters amicably. What do you need to see? Only thing is it does not prejudice your right for arbitration and litigation. So one thing I would say for mediation is that just as in court processes, we also have mediation. There's always this issue of what you say during the mediation will it prejudice arbitration and litigation. So perhaps one of the best practices then would be to insist that whatever is said during the mediation stays during the mediation. No recordings, no utilization of any emissions made during mediation data for arbitration and litigation. Trust me, it can happen. So you got to be very clear about this. Don't give them a chance to use it later against you, in case it doesn't succeed. Number two, expert determination. Education again does not require expert determination as simply requisite. Any disagreement can be referred for expert determination. Why do you go for expert determination? What scenarios? Anyone? Exactly. Issues involving mechanical, CNS, highly technical issues involving architectural issues, and so on and so forth, where it's not so much a contractual issue, but a technical issue. So bring in an expert to come and sort things out. And the experts are not, stand corrected, are not limited to just those from the PM. Right? They can also be engineers, they can also be QSs, so on and so forth. So expert determination can involve us again at any time during the project. So parties may refer any disputes. If they fail to agree, you get the judgment and come in with it. 14 days of the date of the written agreement, we can apply. Prior reference is not a condition precedent. Now, the only lacuna or hole in the law here is this, there is no timeline within which an expert needs to be recommended by the president. So that is one thing there. Secondly, the decision of the expert may not necessarily be binding on the parties. At least you agree to that. You can do that. It's stopping you from doing that. So this is expert determination. It's good because during the project, rather than getting bogged down in the whole thing, just get an expert to solve one very, very technical issue. Then you move on to the next step. So again, it depends on the nature of your dispute. If it is a minor issue or an issue of contractual matters that parties don't really want to find it out, get a mediator. If it is a technical issue, you are saying this is how you're supposed to do it, they are saying no, you get an expert. But again, none of it is binding, none of it is adversarial. You don't, the relationship with the parties ought to still be cordial at the point. What about adjudication? Adjudication is a condition precedent for arbitration under clause 30.4 prior to practical completion. The employer will be able to deduct any non-incurred costs, losses, and expenses, and adjudication rules effect. Now, one important thing to understand is if you read the wording of the provisions of this particular clause, what it says is this: there is a narrow scope of dispute arising from set off under clause 30.4. So set off here involves the employer only, not the other party. So why is this so? Well, that's how it's worded. That's issue number one. Issue number two, adjudication. The more we get adjudication, what comes to mind? SIPA, isn't it? So what is the position of SIPA? Miss Avia, the time adjudication?
Time adjudication is lopsided.
How would you say that, sir?
It's just side to one side only, it's not bad, very not bad.
Okay. I would say rather than saying it's lopsided, stand corrected, take your view, is that it is narrow in scope. It only involves this particular kind of dispute. The dispute where the employer claims set off. Anything else you don't go for adjudication. Number one. Number two, SIPA adjudication, the scope is much wider. Now, my next question will be this. The next issue is this. The procedure for PAN adjudication is different from SIPA. As you say, PAN adjudication, you go to the PAN president. SIPA adjudication, you go to the AIEC. AIEC can appoint any adjudicator they want under the AIEC. Recommend selects adjudicators based on the list of adjudicators they have. Your PAN adjudication, it only comes within whatever the 2-1 acclamation recommends. PAN recommendation, so it's different. So which takes precedent? The law does not, at least the PAN contract does not say you cannot go for SIPA. In any event, current provision of law is you cannot contract out of SIPA provisions. I'm sure you're aware of that. You cannot say this because I put a clause that no matter what cannot go for SIPA adjudication. And I'm quite sure you're also very well aware of back-to-back payment for the SIPA. I actually had a case like that a few years ago, so I still remember it very clearly. So back-to-back payment process are part of the law. So even though you may have contracts or any act of law or whatever this is that this allows freedom to contract, but back-to-back payment process are not allowed. Why? Because SIPA is part of the law. It's not just a procedural law, but it is a law, just like the Contracts Act or whatever you call it.
I think banks hands were quite tight. You're trying to navigate between the handling of SIPA. They have a very narrow view on it. So that's why they end up causing loss side.
And now I get what you say. Okay. And to be fair also to I mean fair, I think as what they are trying to cover here is one narrow debate. And in SIPA itself, it doesn't cover all disputes, you know. It only covers disputes for sums payable. That means if they owe you money, they have to pay you. If you don't owe you money, you can go on the SIPA. Damages and all this will come under that. So there is another, as you said, distinction or the limitation of the scope of SIPA claims also. So we can go through this later. I will pass you an updated copy of the slide, so don't worry about the photos and all that. In fact, I did some newer cases also, 2021 cases and so on. So it's a bit of few more cases for your reference. Hope it helps you guys. Okay, so what about SIPA 2012? Okay, I got quite a few slides on SIPA. I'm quite sure you are familiar with it. I just touched the key areas of SIPA there, so then we can go on to the final part of arbitration. Alright, if you have any questions, please stop me. Okay, Construction Industry Payment and Adjudication Act, we are all familiar with this. Okay, to speedily and summarily address payment disputes. It's supposed to be a quick and dirty judgment in order to assist parties before for any kind of project. Usually to help the smaller fish, so to speak. Now, quick and effective solution, you all know that. It declares all back-to-back payment arrangements, pay and pay for pay process is not required. I had a case of this few years ago. We represented a consultant had an agreement with the sub-consultant for a project. So the employer, in that particular case, the client, refused to make payments as agreed to the consultant. Consultant subsequently, of course, stuck in a difficult position. He had a contract with the sub-consultant, unable to pay. Sub-consultant sued. So this was one of the first few cases of back-to-back payment process, just when SIPA was just coming in. The first round we actually won. You know how? They sued the wrong party. So it goes back again to locus. Who are you suing? So in this particular case, when you sue a party, for example, the agreement is signed between two parties, right? Who signed the agreement? The individual or the company? So if the individual signs the contract with another individual, you can sue the individual. If the company owned by the individual signed a contract with the other individual, you have to sue the company. So again, I'm just using it as a simple example. So these simple basic things are very important. Sometimes we talk about all the complex issues of the law, but it boils down to the basic core ingredients of contract. Of course, in that particular case, they ultimately did make payment once money came in. It was just an issue, just didn't buy some time. So the first round, you sued the wrong party, so we went and knocked it off. Of course, later they came back again, we raised issue of res judicata and all this, but ultimately payment was made. Less than a year. But this happens. Okay? Next one. SIPA award can be immediately enforceable. Now, there is a thing here where they say that once you get an award on the SIPA, you still need to go to the court to register the award. Does it mean that if you don't register the award, you don't have any thanks, don't have any teeth? No, you still can. There are recent cases that say that with a SIPA award, you can proceed for 1 year. And as you know, this hits them where it hurts the most. Because once you have the 1 year petition out the way, everything goes haywire. That's why I think the 466 was a while ago. Right? Thirdly, willing party basic payment is from the principal, directly to the principal. And the principal cannot run away from this. He has to make payment. As long as you get an award, you instead of 4 of the principal, section 30 is right. Lastly, willing party may delay or slow the rate of progress of works which otherwise may not open to them. So this great. Now, I just want to cover what is not covered in the CIPA claims. If it is not a construction contract, not in writing. So, hypothetically, a fully oral contract, we normally go by voice messages and a fully oral contract as voice messages, exchange of voice messages may not constitute a case that is fit or competent for CIPA. Next, work is out of Malaysia, nothing to do with us. Thirdly, below 4 stories high, and of course, for own occupation, 2 months leave, it's 1.5. Okay, scope of CIPA, construction contract made in writing, again, just to share. I had a matter, a CIPA matter a few years ago where there's no formal contract. Emails, WhatsApp conversation, plus, no, emails, WhatsApp conversation, invoices, held in totality to be part of a written contract. Okay, so, but please, like possible try to have a formal contract. It covers you, at least you know what you're facing. Next, cost of action on the date of the breach. Again, it applies to final claims and progress claims. Like it does not necessarily need to reach the stage of CPC. So you can go at any time. Okay, even after that, hopefully. Under certified and certified claims can also be referred to CIPA 2005. Okay, now these are, we can go to this later. So contracts to construct, extend, install, all these things come on the CIPA, number 1. I won't take your time with this. Contracts to carry work which form part of site clearance, soil investigation, earth moving. Now, why I'm bringing this is because some clients or some parties that we have faced, they are under the impression that it's only for hardcore construction project. Actually, cannot construction. You build something dynamic or CIPA claims, not necessarily. Even consultancy work carried out, in furtherance of construction work can also fall under the ambit of CIPA. So the scope is quite wide. Even procuring construction materials, equipment, or workers. So for a project, you get workers to the project, that is also will also fall under the CIPA claim. Not the building proper itself. And construction consultancy work, the famous case of architect Neo, federal court decision. Now, only architects, engineers, and quantity surveyors registered in the Act can provide professional architectural, engineering, and quantity surveying consultancy services. So my thoughts would be, if you do not fall under these categories, your consultancy services would not entitle you to proceed with the CIPA claim. Architects, engineers, QS. Because we all have professional acts governing us individually. Okay, quick run through of the procedure and timelines, very quick one. CIPA 2012 education process, decision, and crucial timelines. Okay, this is the time, the flow chart. I hope this helps. This will be helpful to all of you all, sure. Okay, the moment you make a payment claim, 10 days, payment response, 10 working days. Then we proceed to notice your adjudication, appointment of adjudicator. If you have no issues with the appointment adjudicator, you have 10 working days, adjudication claim 10, response 5 working days, adjudication reply to the date of delivery or adjudication decision within 45 working days. Then of course enforcement. Why is this important? The timelines are strict. If you do not comply with the timelines, you trouble. What normally happens is, number 1, the adjudicator comes up with a decision for award after the 45 days. What happens to the award? 1. Number 2, you have your adjudication response, adjudication reply, right? What happens the adjudication reply is filed all the time? We've had cases, in fact, I had one case where the adjudication reply was filed out of time, really out of time. And then the judgment came out, the award came out, we contested it. We said, why didn't you consider my response? So as far as the court is concerned, I'm just supposed to give you time until this day to file the reply. You are delayed, you are late or whatever, that's all must happen. Okay, but very importantly, if the adjudicator comes up with an award after 45 days without obtaining the agreement of both parties or whatnot, extension of time, and so on and so forth, the said award can be set aside. Idea is very simple. After 45 days, you don't have the right or the jurisdiction to come up with an award. Not an award, just say that. Yes.
If it's about just a few days late, because the adjudicator act is
The word has to consider because we have the you read the wording of the act itself, right? They have to do it within a particular time. So he can come back and say, well, I've already come out with my award by then, example, then probably check out anything lah. Let's say you came out 1 or 2 days later, the correct process my thoughts would be apply for extension of time. If possible.
Your party will show
Of course we want. So, but don't forget the educator has certain powers. So they can argue that he exercise discretion properly. But you know the timelines are strict. The whole idea of SIPA is supposed to be strict timelines. So you are supposed to come with a quick and dirty judgment in order for the parties to move on to help the smaller players, especially. So time is sacrosanct. Another very important consideration is to go on before I forget. Now, when you draft your adjudication response, your what do you call this? Adjudication claims, adjudication response, and reply. Are you bound by what you put in? Let me rephrase that. Okay, originally you put in a payment claim. After you put in a payment claim, you then go to the stage of adjudication claim. Can you compare notice adjudication claim? Okay. But if you have never raised something in your adjudication claim at all, can you raise it during the submission stage? If you raise it during a submission stage, okay, what can then, sorry, let me rephrase that. You have never brought up something during the adjudication phase, I rephrase my thoughts, sir. You didn't bring up something during the adjudication phase. But in the award of the adjudicator, a different issue was dealt with. An additional issue was dealt with. Adjudication aim talks about 3 things, but the award goes and talks about 4 different things. If we go beyond what the parties have brought up, then can also be liable to be set aside. So these are issues, challenges that you can make. How do you challenge an award? Okay, all these things we can cover. Payment for services rendered. Okay, repeated damage, post termination, damages claim. Okay, so I believe we all know this, but we are running short of time a little bit. Okay, but now I just cover in brief. Okay, key procedural elements, you have your payment claim. Okay, number 2, then you have written notice to adjudication within 10 days to agree by appointment of adjudicator. Then you have the adjudication claim within 10 days after acceptance of appointment by adjudicator. Adjudication response again 10 days. Previously, adjudicator must consider all defenses even were not first raised by a payment response earlier. So you can, as long as you raise it later, you have to raise it. The question is, if you don't raise something and then the pandai got decide on something that you have not raised, then it becomes an issue. Because you're deciding beyond the ambit of the case. Thirdly, the adjudicator must decide the dispute and deliver a decision in 45 working days. Okay. Adjudication decision is only temporary and can be re-argued by arbitration or litigation, losing party pays or adjudication costs. How do you challenge the award? You set aside. Number 1, you can set aside under section 15 where the adjudication decision is inappropriate, limited grounds, fraud or bribery, denial of national justice, adjudication is not acted independently. Last one, in excess of jurisdiction. So excess of jurisdiction comes in where you come up with the award after 45 days. You come up with the award taking into consideration matters not raised during the process. What is excess of jurisdiction? Okay. Very crucially, a setting aside is not an appeal. So you cannot set aside even if there's a finding of fact in error. When you go to court, you file a case in the High Court, we appeal the matter to the Court of Appeal. You can raise matters issues of finding of fact and or law. When this is adjudication decision under SIPA, when you apply to set aside, the principles are not the same. In other words, Rayuan, as we call it, or appeal, the principles to succeed in an appeal are not the same as the principle or the principles to succeed in a setting aside of an adjudication. The test is a different test. So, hypothetically, even if the adjudicator were to make a mistake in the finding of fact, this may not be something that we can challenge. Okay. Next. Adjudication decision is final, binding, and can be enforced. Stay order. Can you get the stay order? Yes. Section 16 of section 1. You apply the setting aside application has been filed and is pending final determination by arbitration of court. So a temporary stay pending appeal pending setting aside. Enforcement. How to enforce? Section 28 of the CIPA Act, you need to register the judgment and award in the court. Okay. You can also make a demand directly, section 30, PCOM specific states, main con, sorry, employer, main con, subcon. Subcon manages to get an award against the main con. You can then go straight to the employer, get payment. In addition to that, once your award is registered, you can go for JDS, judgment debtor summons. Garnish, this is I think you have heard of it before, to garnish the bank accounts with the seizure and sale. And lastly, of course, winding up. My thoughts would be go for winding up because right for over 50,000. It hits them where it hits the hardest. Okay. Okay. So again, same thing also, suspension of work, you can come with suspension of work under CIPA. 40 days notice, but you must give notice. You can only do the suspension of work if there's a 40 days notice. Winning party may apply for direct payment and conditional payment process are disallowed. But certification of work prior to payment does not mean that it is a cross prohibited under CIPA. There was a case where they say that the fact that you need to certify before you make payment to me means that it is covered as conditional payment clause, which shouldn't be allowed under CIPA. It's not a conditional payment clause. It is to exactly how much to pay you accurately. So it doesn't fall apart of CIPA as such. So the reason why I'm pushing this is that CIPA is not just a procedural law, it is also a substantive law in terms that this is a contract act or whatever you call it. What is stated there becomes a law of the land. We have to take this consideration. Lastly, arbitration. Arbitration is referred to for any disagreement or dispute, won't start under the works either practically completed, need to be practically completed, so until the employment is determined or claimed, until the works are attended. Your provisions to the Arbitration Act will demand current time arbitration rules apply. Arbitration is the exclusive dispute resolution. This is a federal court decision. In that only against wrongs here. So the process of arbitration is under clause 37. Basically the same thing. You go wait for the president of Fed, apply for arbitrator to be appointed to sort out your matters. He follows the normal arbitration process. Okay, what did you do? 3 very important things. Documentation. One of my earlier experiences in construction methods I was sharing a while ago outside. We acted for a company that was served the same conflict, very significant sum. We needed to prepare a defense. I approached the client, okay, where are your documents? They brought me to a room, open up the room, it's all documents here. Where you are? The person was sending these matters no longer here, but let's go through it. So we spent the next 1 week and a half literally sleeping there, looking through all the documents, getting POs, invoices, contracts, letters, correspondences. And you are put in a difficult situation because they have all the cards there, they choose what cards to put, what documents to put. Our client said, hey, after this letter, there was another reply. Where is it? I think documentation is absolutely crucial. I'm sure you all practice proper documentation, but please, very important. Go the extra mile. Your conversation with clients, WhatsApp, email, whatever, keep backups. Put it in the file. You have a conversation, write down, make a note. Number 1, documentation is key. Number 2, say updated regarding recent developments. Dr. Abdul Hamid's case is very straightforward. As a professional, you must be you must keep abreast of latest developments in your field. You cannot say, no, I didn't know that there's no technology for this and that. You have to test practices. This is expected. Failure to do so can amount to a failure of breach of duty of care. Thirdly, inform insurers once there's a claim, inform insurers or quick professional advice, prepare an independent technical report and reply to all correspondences and notices of demand. I'm sure your person indemnity insurance, there are certain requirements to inform the insurers, don't sit on it. You have to inform them within a period of time. Don't simply just reply, so on and so forth. They may have one of the things that are advisable is run your replies to the insurers before you reply. Okay, so on and so forth. Thirdly, it's crucial why shields you in your firm against negligence arising from advice, services, design, supervision, etc. Now, I can't emphasize this enough. I've had scenarios or situations where we've had clients, consultants, approaching us. I got sued. Unfortunately, I'm not covered. The effects are quite severe, I mean, in this particular case, went through a lot, the individual went through a lot. So, please, I do not know it's mandatory for you, not necessarily, isn't it? But do consider that. Okay, I'm not speaking with insurers, I'm not on the board panel or anything like that. I'm just sharing something from my personal experience. So this particular case, the effects on that individual were quite severe. At least you have this, it covers you. It doesn't mean it will always cover you, but you have a blanket to cover you, a sheet, so to speak. And as I said from the very beginning of my presentation, people out there, the man in the street, knows their legal rights, which is a good thing, I agree. But it also means that we have to be vigilant. Okay, as professionals, that is what we have to do. Our clients can be our worst enemy, as they always say. So we got to protect ourselves. All we want to do is to carry out our job, cari makan as call it. But in doing so, we have to be aware of these features and glitches. And that's about it. Thank you very, very much for your time. Questions, please. You have time for questions? Any queries, any questions that you have? I will share the slides later. Any personal experiences that you have that you'd like to share with us? A friend of a friend, asking for a friend. Yes, sir.
Just for experience.
Yes.
The documentation is very important. But we want back to cases just because of our documentation. Normally, when you deal with contractors are very bad at documenting. So if you have yours, I mean, you are on to it. Yes, there's no just word of advice.
Thank you.
Yes, full experience.
And I'll just add on one to what Tuan Haji just said. Every letter that you send, every document that you prepare, assume that you will end up in court one day. That this document is going to be looked at by the judge, by the lawyer, by the other parties, by expert evidence, expert witnesses. So think of it. Paranoid a bit, well, you got to take care of yourself, kena jaga kita lah. Take that into consideration. Every letter. Because this is how think that it may come there. Then deal with it accordingly. We had scenarios where again not to exaggerate, a single word in the contract can mean so many things. They argue on one term. I had one contract, one dispute just to share. The entire contract was successfully completed. But the entire dispute that went for arbitration for a very large sum of money was just on one word. What is site? S-I-T-E-N. What is defined as site? So we involve whether works will carry out on site or outside, out of site. So if it's carried on site, the calculation or whatever you call it will follow current market prices. Sorry, will follow what's agreed to in the contract. If it is deemed to be work carried out of site, we have a price variation clause that kicks in. It follows whatever is the current market price. But the issue is on the site because we're carrying out construction works here. Next to me, there's an open area there, which is also under the control of the client. What is defined is this is the site. Isn't this the site also? So the difference between one and site is a multi-million-dollar question.
Sorry, let's say there's an issue regarding documentation, right? Is there no concept of discovery?
Of course, it's concept of discovery. When it goes to civil litigation, then you have a concept of discovery. Of course, arbitration is slightly different. But again, the test for discovery, we just had a case in the High Court recently. There are certain requirements that you need to fulfill. It cannot be a fishing expedition. You must know what you're asking for. In other words, you cannot say, you ada document macam ni kan? I know you have this particular document based on what you say in your pleadings. I want this particular document, for example, because then of course the next question is how does this affect the matter before the court? So you have to go to discovery. We had one very 3 times we went before the High Court just on the one small application. We refuse to give discovery. See, you are just should be hoping for something to catch us. Sorry, but Yes.
Okay, in the basic question. Sometimes professional but court.
Yeah.
For example,
we have building permits, approval processes, right? I think most of the professionals here have been through this kind of thing. So the owner wanted to start a project, but the principals and people must be are in line, right? We are responsible. So because of that action by the authority, which we to what extent do we arrive? If we have issued a warning or advice to the developer, are we out of the responsibility or are we still liable for it? If we get sued by the PDT or even the Bakal for doing that. But sometimes, in fact, we do jobs for the government, they or whatever. Even private developer, they just, they just put those. So how far are we like for it?
Okay, very good question. I always follow what my mentor, my master, study practice always told me. As lawyers, as engineers, as accountants, or whatever you call it, architects, we all have our principles that we don't touch. If we feel something is wrong, no matter what, if we have, and of course we cover ourselves, we give them proper written warning, we're given our opinion as a professional, you shouldn't do this. As a professional, you need to be aware of this. Yet they insist on doing things that are not right. My humble thoughts are, I can't speak for everyone else. I'll put my foot down and say, no, it's not. I'm sorry, I have to discharge myself. Protect yourself. As I said, sometimes we do have to show that, we hold on to our principles. And more importantly, the practical part of it is, if something blows up later, I have done my job. I informed them, I put it on writing, I done my job, I step back. Don't get ready.
What if you do step back? You still attend meeting, you work carries on, but I have advised you already. What happens then?
Okay, again, as I said, from a ethical perspective, if you feel what is wrong and you're not expecting it as a profession, you should step back. Let's say for some reason you don't. The fact that you've given them adequate warning, you've given your legal opinion or your professional opinion, and yet you choose not to follow, then this would be a possible shield for you in any further proceedings.
That's why the documentation is
Very important.
even the WhatsApp message on those country,
Correct.
for the letter.
Yeah, but still, if it is a severe thing where you think there is going to be a severe repercussions later, I would say you might want to consider your position. No matter what.
Real case lah. The engineer actually pull out. The engineer actually pull out. So you work as a top for 7 months, the new engineer is point to back. But this is a professional. What you are saying is that you put out this one.
Yeah, you should, because remember, the worst thing, okay, I wouldn't say the worst thing, one of the biggest weight on shoulders of architects, especially, which your role is KC. That is something that sticks with you forever,
Yeah.
So it's a very heavy burden. Okay, and I truly empathize with all of you. But that is where, as I said, we got to draw the line. Sometimes our professional pride, what we do, and more importantly, to avoid problems later, we need to draw the line. If you're doing something that is absolutely wrong, I'm not going to be market. I mean, money you can get someday somehow or other. Of course, it's a tough market. We all want to make money, want to live our lives. But some things are non-negotiable. Especially if we know it's going to result in very severe repercussions later. Use of material and so on. Why would we part to that? But this is my personal thoughts. I can't legislate for others. But if it is not that bad and you just want to cover it, then you say, yeah, okay, I'm giving my warnings and so on and so forth. We had a scenario in which there were some changes made during the project. My consultants informed them, this is what we need to do. They failed to do it, they then got into trouble, we just show the documents, they didn't even sue us. Yes, sir.
Another scenario, you are the PSP, but something done or not done by your engineers, and then you get dragged into the dispute, and you get fined for it. What do you do?
Go after the engineers.
Yeah.
When they go meet you directly. I mean, I'm just giving a hypothetical scenario.
Separate appointment. They're not under us.
Okay, who are they, sir?
They don't have a contract with us.
But again, as I said, if there is a mirror marking between you and the third party,
For example, let's say another classic example, the one in PJ, the section 14, the tires in market, the
Okay.
collapse. That was under the Bush works, really.
Okay.
And yet the architects got dragged into the dispute and got fined. So he was able to fight to the contract of demonstrable. See, okay. Another example is our famous Tanjung Bunga site, which is the work is done by engineers, not architects, and was dragged into it. So we as architect, in those conditions, how do we protect ourselves in terms of the law?
Were you aware of what was going to transpire before it happened? No. They had no knowledge whatsoever, beyond the scope of knowledge. My argument would be, I'm leaving aside fines lah. Issues of negligence, there must be a duty of care. So I'm just hypothetically saying,
The fact that you are the KSP.
that's the problem. The PSC comes in. But again, it's just a sheer negligence thing. Again, I go back to basic ingredients. You have the duty of care. You can only have a duty of care for what is within your knowledge and expertise. Correct. No, I had one case once, just to show a very different example. I was representing the consultant in a particular field, but the expert evidence witness that they brought in was of a totally different field. So how can you appreciate the work that my chap has done? So same principle. If you do not hold or you do not bear a duty of care for areas beyond your knowledge, unfortunately the PSC issue comes in. That one, of course, is a big heavy load on your heads, so to speak. But again, fact sensitive. Maybe you say you have a scenario like that, then think we go to the facts, we might be able to do something about it.
The insurance cover that part.
Cover that.
It doesn't.
I'm not too sure. I will see the policy, don't know it's. I'm not too sure about it. I need to read the policy. But this is something different a bit.
Because the PSP is a big work.
It's a very heavy burden. Again, even your G forms, when we have spoken to engineers before, once you sign the G form, you are bound for life. Wherever you go, whatever you do, it's always that G1, G2, G3, whatever forms. Yes, sir.
Yeah, I have a question just for general knowledge. So regarding this PAM arbitration, does it come under this New York Convention? And this PAM arbitration rule, does it confirm this procedural rules?
No mention is made of that in the Act. All the Act says that as far as we concerned, it comes under the Arbitration Act of Malaysia and the PAM arbitration rules. It doesn't go beyond that. But again, I would argue it doesn't say no. So as are we bound by the UNCITRAL rules? Are we bound by the New York Convention as a whole? If not through the written express words of the law, through previous judgments in court, right? So that would be my answer. There's nothing saying that it is not, there's nothing saying that it is. Just like nothing specifically referring to the SIPA regime, but nothing saying that it isn't.
Because I don't know, I just look at AIAC because it's part of this ALCO, it's an international body. But however, some
Exclusive.
But somehow it's really and when we look at it, and it's like something like setting up something on their own.
Yes.
So how does it apply to the arbitration if it's under this PAM contract? How does it apply internationally?
I would say that it's food for thought. I will need to consider that and give you a better answer. Why don't I check on that and get back to you on that? I think it's a very good question because you see, currently we all go through the AIAC, we are bound by AIAC and whatever that. Now this is a concurrent or parallel kind of a thing where it goes to the PAN itself. Your arbitrators are not appointed through the AIAC this. So how does it stand? Does it stand master abroad? So that that's an explosive answer to an explosive.
So, I mean, like our Malaysia, arbitration rules, it doesn't mention pen. So if there's any cases, if someone wants to enforce it, like for instance, in a Singapore court, and they do it with under pen.
Very good question, in fact. I've not considered this before, to be honest. If it comes under the Arbitration Act, right, if it's a CIPA award, you can register it in court and hence it becomes enforceable. Arbitration awards can also be registered, can become enforceable. I need to check on that with you, because it's a totally new area, it's a curveball, it's an interesting question though. I think I would need to do some reading up before I can answer you on that. Now we have to be honest, you know something you say, it's a very interesting question, in fact, because to be fair also, pure pen-based arbitrations are not that many. You always go through the AIAC route. So now what happens if you want to go down this route? Would your, in effect, your award be recognized abroad? Good question. Let me check on that. Let me think of it. Let me check it. I want to know the answer. Very good question actually. I not thought of that. Again, this is where the issues come up. We have CIPA, we have PAN, we have arbitration and then the AIC, then we have PAN. So how? Very good question. Let me get back to that. Yes, sir.
I had one case, it didn't work anyway, but we were negotiating with American firm. So bottom line is at the end of it, said American law applies. The work is here, the client is here. So where does it come?
Okay, very good question. Normally when we come up with contracts, there are two issues when we draft contracts. There are many issues, but two key issues. One would be what are the applicable laws under the contract, especially involving multinational corporations or clients abroad. Are we applying the laws of Asia? Are we applying the laws of Singapore? Are we applying the laws of US? One. Number two, equally important, what is the seat of dispute resolution? Or we call it, sorry, how do you resolve disputes? Arbitration, or do you go to the courts? So that's also one issue. You say first, because as you say, remember I went through section 34, 35, and so on and so forth, where you go through a cascading system. You start off with mediation and litigation. Is it a mandatory provision? Number one. Number two, do you go through the courts? Number three, very importantly, where do we go to resolve our issues? What is the seat of dispute resolution? UK, Hong Kong, Singapore, Malaysia, whatever you call it. Ordinarily, again, this is what I've observed, when there are two different parties involved, they normally may consider that US and Malaysia, for example, they may consider a neutral ground. So SIAC, for example, Singapore International Arbitration Center. So that may be one way out. Okay, because you don't want to go there, costs are high. At the same time, they don't want to come here for whatever reason they have. Example, so you may go down that path.
No, what he said, American law applies. Right.
How it has to be bound by that, because once he says that you sign a contract, you can sign a contract in Malaysia, okay, but agree that the laws applicable are US laws or UK laws or Singapore laws or India's laws or China's laws or any laws of the country, Indonesia, up to the parties involved. That means, see, the contract is a contract, but in interpreting the contract, enforcing the contract, and so on and so forth, we go and refer to the laws of that particular country. At the same time,
Can be done.
and then also, very crucially, and I say the more equally crucial question is, where do we resolve these issues? So we could have a hypothetical scenario. I want to rely on the laws of the UK, but the seat of arbitration is, example, in Singapore. Boleh? Why not? I mean, freedom to contract, nothing, but I mean, fact centric, and this is a general overview. Okay. This is a crucial question to always ask, but it's a very important question to consider when you are working with, counterparts, international counterparts.
If none are cited, that's local laws.
Nothing saying that actually, because it's signed in Malaysia, well, the assumption would be that, I mean, you can say, if you're signing a contract with a Malaysian company to carry out a project in Malaysia, we don't say what are laws applicable, then you maybe assume that, but for me as a solicitor, I would say you have to say, you have to put it out. How can you have a clause? With respect that, I would consider it to be not so well drafted, if you don't have that. It's important, but you have to cover your bases. You see, this is what we refer to as lacuna or loopholes. The whole idea of drafting contracts is to reduce uncertainty for parties. We want to then know that a properly drafted contract will tell them if a problem occurs, what do you do? How do you go about doing it? What are the expected obligations the parties involved?
Not all contracts are contract.
Of course. But I think this is a very crucial clause, especially when dealing with international parties. You must have that. I mean, standard, unless you decide not to, then there's another question. Questions?
Okay, one last. This is the thing. If you are, we had a case of earthwork. Okay, we have got the perancang, okay, perancang. And then the
Permission.
permission, okay. Then the client decided, to go with the earthwork first. Then our building plan has not been approved. Okay. And the engineers got the permission or the permit for the earthwork. The work was carried out. We started to get going. And then they don't have any audit. And we were blamed for it. Where does that come from?
Again, put it on writing. Now that is how it's supposed to be. This is the process, this is the procedure. These are the steps that you need to carry out. You can't jump. What need, then you do this, and you do this, and you do this. If you they'll come back and say, you as the professional have to advise me to do what I'm supposed to do. I won't know. So you put it on writing, this is how you're supposed to do it. You still choose to do things not according to procedures or processes, then it's your risk, your liability.
That means we are out of it.
You have
Because in this scenario, yes, he worked along that time because he just worked with the engineer. Without our, we were not called for the meeting.
again, if they purposely excluded you from meetings and so on and so forth, again, knowledge, do you know about this? Did you come to find out about this data before things popped up? If you do, put it on writing. Again, I think professional integrity matters. If your own employers, again, in respect like CCA, if they don't respect you as the architect at DSP or why not give you due deference, it's a professional, step back or put it on writing. You still don't do, apart put it on writing. You did this, it's not right, you excluded me, example lah.
Okay, the problem is, Majlis Perbandaran wrote to us, asking to explain why.
Actually, again, the thing is, I'm the DSC, yes, but I was in the dark, there's no way of example lah, no way of me doing it, they excluded me purposely. Of course, you can back and say sign instruction, which you know right. I'm saying the first inspection. Jangan bulan the first inspection, they will come back lah, we know what they will say lah, kan. So again, I understand you're all busy, but in as much as, again, my personal thoughts, in as much as we want to protect our personal integrity, how we do our work, what we have to do, we have to do. We can't run away from it. If we do that, then it opens us to a lot of can of worms, problems. I know we are busy, but we have to do what we have to do. We must be aware, we are the PhDs, we cannot say we don't know what's going on. I mean, that's my personal thought lah. Okay, thank you. Questions? Very interesting questions. If I don't know someone will say that. Yes, sir.
Just want to dwell a bit on the professional principle and the bottom line that mustn't be crossed. Actually, it was a case that we experienced. And we had this case where the contractors and under the instruction of the developers was doing work that is not in accordance to our what you call guidelines and safety practices. And we wrote to the council. I mean, that's where the crux of the problem starts. When we wrote to the council to withdraw ourselves after numerous what we call returns, warnings, meetings to tell the client not to do, and the client still instruct the contractor to do so. Subsequently, we wrote to the council saying that the council said, no, you cannot do that until a new architect is found or a new PSP found to take over your job. So I think this is the practice that council is, or the standard they are adopting. So subsequently, we consulted our lawyers and we decided to pull out because we know that actually when we tell the contractor not to what you call operate in the what you call illegal or unsafe measures, the contractors still do that. And the site is totally out of control, so and during the transition period when the new architect was being appointed and we wrote to the council and we insisted and the council disagreed, subsequently we still withdraw ourselves. So that grey period of zone, should anything happen there, and it is, I feel that something that we as professional practices we should adopt. And I don't know, because the council to these days still in a way blacklisted us based on that sort of practices. So what do you think we should do?
If I were your lawyer, said, my thoughts would be this. My contract is with a third party, it's a commercial contract. How I choose to go about it, if I am terminated or I start to live in a contract in a manner that is a breach of contract, it is for them to take action against me. So I would say that with respect to the council again, I'm not aware of the facts. In a hypothetical scenario where I wish to do something under contract, it's a commercial bargain between me and another party.
Yeah.
Let me do that. I want to withdraw myself, I want to stop work, I want to slow down, whatever it is that is for me to deal with. Council, with all due respect, well, it's between two parties, why are you saying again?
I cannot be the enforcement power, they think that, I mean, in the midst of changing of architecture, and should the, what we call, the contractors still carry on, developers, contractors still carry on as in line, and at the end,
If something happen, I feel that the council in this particular sense, they will they come up to us lah. They say, hey, I mean, it's not the council's responsibility, and you are the PSP, and we still have not accepted your withdrawal. So
I mean, those are
it's a leading factors that I think that will happen again and again.
I said what I said, I think it's a commercial bargain. Number two, my next question would be, does your contract allow for works to continue and there's no architect on board? So when you do work and there's no architect, is that your fault?
no, but the things that council thinks that it's our fault.
Okay, maybe the limits of respect, I'm sure they also have the legal way of looking at things. I'm not going to say they're wrong.
I mean, it in a way, to a certain extent, passing the bucks to us consultants. So, I mean, we did what we have to do, so I withdraw and then I send a letter, send CC copy to the council, whether they agree or not, it's not, I mean, it's not within my jurisdiction, so, but in doing so, I mean, you might antagonize or you might infuriate the authority, so there are some repercussions.
I don't really understand. You're put in a difficult situation. If you don't do something, eventually you're going to get in trouble.
Yeah.
You do something and then as you say, you're in trouble. But I stand by what I say. There's a contract. I am free to do what I have to do under the contract.
Consultants, we stand by our principle.
Yeah, we stand by your principle.
We let somebody to, I mean, we can't.
Right. And I think the corollary to that is that when you see that once I am no longer on board, you're not supposed to do anything. If you do something when I'm not on board, I mean, based on the contract itself, then it can't be attributed to me. I already set up. So when you doing work in a way that is not mandated by the contract or laws work, then you are in trouble on me. So of course they can cold storage and whatever is what you said and so on. But again, it's the same. Sometimes you just got to make the with respect the tough decisions and stand by them. I'm quite sure as long as you hold yourself to integrity, you hold yourself to highest professional standards, I think it will hold you in good stead, whatever comes after that.
Coming back to this issue of local council, some of the time they don't do things according to the law. I had myself too, like this. I had myself like this also. But when we appeal, we discovered that those things are done by the king officers, not the council. The council will decide. We had to appeal to the YDP, and the YDP only discovered things are being done by these legal audience, see, which is not according to law. So I advise the council, you are not authorized to practices, only the lembaga can practices, take action practices.
Normally, whenever you get issues, so especially involving all this, we ask one question. Do you have the power to do what you are claiming you want to do? That's the first question, like you say, so on and so forth. And again, I reiterate what I will say. Sometimes you have to make a decision because the repercussions are much more severe. One. Number two, you're just maybe carrying out your contractual obligations under a commercial contract with the greatest of respect. Of course, we all want the projects we want. But well, that is for example, the employer to come up maybe if there's a delay or there's some issue related to the project. So it's a commercial issue. But with the greatest of respect, I'm sure they have their own view on this. That's
If you're sick, then
there is a term in contract called frustration of contract. Whereby a contract can no longer be performed due to events beyond the powers of the parties. Suppose if you're incapacitated, you're unable to work and so on, you could rely on the clause perhaps. Section 57, I believe, corrected contracts.
Yeah, the problem in terms of authority, architect is always responsible.
It's a very heavy burden, a very heavy crown to remove. The project can only run with you all, but at the same time, they put a very heavy burden on the users. I understand, I empathize. I had a case on this before. Well, as they say, God gives those, then he puts the heaviest burden to the broadest of shoulders. I see all the shoulders of my strong. Carry the whole project on the shoulders. Any other questions?
Okay.
Thank you again for your patience. Thank you again for sitting down on a Saturday morning for hours listening to the talk.